Adjournment request, if any, from item number 1 to 7.
The item number 5, 6, and 7. I am going to file this affidavit on a during course of the day.
On behalf of whom?
My lord, Revenue Department, my lord.
Which department?
Revenue Department.
Revenue Department. Revenue Department, what to do with the Revenue Department?
On the basis of, my lord, that revenue, my lord, that Assam Muslim Marriage Act. My lord, this is, my lord,
The government of Assam is filing the affidavit possibly.
My lord,
It is filed through the revenue.
my lord, show. 5, 6.
No, there are a lot of problems, my lord. They are taking time after time. And this
They are
is very,
filing
I know, my lord, there is no legislation in when they have, there's a lot of problem they have created a lot of.
My lord, what I pray for is, my lord,
mentioned earlier.
I'm also appearing for one of the petitioner in item number 5.
Yeah.
Let the matter be taken up on Tuesday, my lord. There's some urgency will be pressing for some order. Since they will be filing their affidavit today, so it can be taken up on Tuesday.
Then you'll take time for rejoinder or
If
something.
if required, we will file in the
My
meeting.
lord, I am appearing for the legislative department and the chief secretary. I am communicating with the chief secretary also for filing a detailed affidavit. My lord, 2 weeks time is required. My lord,
Again,
Last time already.
Then what the revenue?
alternate
Detailed affidavit must be.
they are filing, my lord.
You are for the state, all departments are of the state, file a combined reply.
My lord,
Why
that
this,
that is why, my lord, consolidated reply. My lord, 2 weeks time is,
consolidated reply, if he is in receipt of the instructions,
My lord.
then why you are not able to get the
So the
instructions?
state must speak in one voice. How can two
That is
departments?
that's what I'm saying.
that we are doing, my lord, for which,
Ultimately,
my
the
lord,
validity of the act is under challenge.
Yes.
The stand of the state has to be same.
my lord, we'll show before this court how the action has been taken by the government. We'll show it, my lord.
That's
And
why
your
We
lordship-
have issued the notices.
Yes, your lordship, first view was that where is the alternate legislation they have to bring it, my lord, no legislation.
My lord, in fact, by order dated 24/6, last opportunity was given. And
That's
fixing
right.
it the matter today.
But since the validity of the act is under challenge.
Ordinance, my lord, not act.
Ordinance.
Whatever it may be, ultimately, the AG has to reply that.
Yes, yes,
He is not by the state government concerns.
right, correct.
To be, the whole act is.
I think, my lord, under the instruction of AG only, the affidavit is being filed today. That's what was communicated to us yesterday.
I don't know. Whether
Okay.
AG is appearing here.
Yes,
As a lordship, my lord, he is out of station. We will listen today, lordship, at 1 PM, lordship. My lord.
no, today we are not saying, let it be on Tuesday, my lord.
Tuesday, my lord. Tuesday, your lordship will.
The net council appearing for the respondent state. Revenue department has submitted that he is going to file a reply on behalf of the revenue department. Today itself, however, Mr. So, Mr. Sharma for
Question of law.
legislative department has submitted that
Oh.
he needs some more time to file a reply. The counter to the writ petitions, wherein the validity of the ordinance.
Assembly बहुत शिक्षक सुन
Validity of the ordinance is at 15/9, my lord, till 15/9.
আমাৰ এইখন আহিছিলে 16-3 তাৰপিছত এছেম্বলি হোৱা নাই খালি মই চালো
Sixteen-three.
Just. Validity of the Assam repealing ordinance 2024 is under challenge. Stop. Since the validity of the ordinance is under challenge, we limit appropriate to direct the learned Advocate General to accept the notice on behalf of all the respondents and to file counter to the writ petition and to file one reply consolidated reply on behalf of all the respondents in these writ petitions or in one of the writ petition.
Covering all the.
Consolidated reply covering all the petitions. Stop. Looking to the urgency of the matter, we deem it appropriate to direct the respondent, to direct the parties to exchange their pleadings by the 8th of August 2024. List this matter for list this matter on 13th of August 2024. By 8th of August, prior to that, you file whatever you want to file. You may also file any.
My lord, reply.
Yes, you require.
essentially it's a question of law anyway let's file the appeals.
Adjournment request from item number 8 to 16.
In item number 1 and 2, Lord,
Item number 1 and 2.
item number 1 and 2, Lord, I am required to file an additional affidavit in the matter. Lord, I prefer 3 days time, Lord. Kindly, if Lordship takes up on Wednesday, Lord. By Tuesday, I'll.
Item number 2, so that has already been, that dispersed, you have already dispersed the compensation amount to those persons, 6 persons.
The amount, those are the amount as regard demolition of the house.
Yeah,
And now in this writ petition in item number 2, they claim that for the death of her husband, the amount is required. Amount
Yeah.
was to, for the death of her husband,
custodial death. is-
they allege the custodial that we have filed an affidavit annexing all the postmortem report and all. And that there is no torture at the custody. But the additional affidavit is required to be filed as regard the action taken against the officers and the amount of release of 2.5 lakhs for the demolition of the house. I prefer 3 days time, 20 days time. I'll bring that additional affidavit on record. It is already sanctioned. The 2.5 is already sanctioned. I have the instructions.
In the 2.5 already sanctioned.
2.5, yes, in respect of the petitioner number 2, 2.5 is already sanctioned. I have the instructions. It will be released within short time. As regard demolition of house. It could not be released earlier because the legal next of kin certificate she could not produce earlier.
May I please, Lordship, that is my lord, with regard to the demolition of house,
Demolition, true.
only that part.
Yes. I'm talking out that only.
It is admitted, my lord, it's a case of custodial debt, my lord.
Just,
That, my lord, on the next date, my lord, since he is wanting time, we'll argue on that, my lord.
Mr. Being up council appearing for the state, there is some time to file an additional affidavit. Time frame for his matter when
But after Wednesday, on next Thursday.
Theoretically, it will be
12th of August.
Lord, hold on.
Mayor Lordship, I am praying adjournment for item number 9, Madam, for a week, Madam.
9,
Yes, Madam.
hearing matter.
Yes.
Adjourn.
Bless, Madam.
May it pleases your lordship. Lordship, I beg to mention item number 14, your lordship.
Yeah.
The consent of the respondents have already been taken, your lordship. Lordship, the matter may be fixed on 9th, your lordship.
Adjourn.
Obliged to. There is an interim order that may be kindly continued, your lordship.
Interim order if I need to continue to the next day.
Deeply. obliged.
Lordship, I beg to mention item 11 of today's daily listing. Lordship, in this matter, we have filed a reply to the affidavit filed by the respondents, Lordship. But we inadvertently, some documents we have not annexed, Lordship.
So what
I
you
may
want?
be allowed to annex those, file an additional affidavit bringing on record those.
Adjourn.
May I please, your lordship? My lord, I beg to mention for an urgent listing of a matter today, my lord.
Today,
My lord.
what's the urgency?
My lord, urgency is that the 5th of August, my lord, is the last day for online application to the regarding the post of, my lord, Gramin Dak Sevak, my lord. And my lord, we have been diverted that there is a dispute has been raised regarding our board and where from, my lord, we have obtained the HSLC degree, my lord. Now, if we miss the, my lord, the last day, that is on 5th of August, my lord, then we'll be nowhere, my lord. We cannot.
5th of August is the
5th of
last day.
August is the last date, my lord.
Tomorrow.
My lord. Obliged.
Daily list for orders item 3.
We have, filed. We have filed, justice services, we serve justice services, but then only upon these two, as per instruction. AR infra, that is, respondent number 9, and that is so put respondent number 10. But we could not serve notice upon respondent number 10. They refused to take it. So we have given the Gaon Pradhan was accompanied along with the petitioner. But then I have enclosed in the affidavit his documents, his certificate that they did not receive it actually. 10. Respondent number 10 refused to take it. Take the notice. But respondent number 9 has accepted the one. My lord, also respondent number 6 is continuing with the construction work, and then they're blocking the roads on the waterways.
There are 3 manifests.
My lord, after the rain, the situation is really bad now, the flood situation. kindly grant us an early date for hearing.
Who is obstructing the natural flow of the water?
Yes, ma'am.
Who is obstructing?
Madam, I have given in the detail, like all of this, all of the, from fifth, sixth onwards, like Pan Ply and everyone, they are blocking the roads, madam. They are constructing, this, walls just on, in the front of the, where the waterways are there.
Because as per the office report, notice upon the respondent number 9 is already served. However, the notice upon the respondent number 10 has not been served. Yeah, we can answer to the petitioner has submitted that the dusty notices have been served upon the respondent number 9. However, the respondent number 10 has refused to accept the notice para in support of the above contention. A report of the Gaon Barua, concerned Gaon Barua,
Gaon Pradhan.
Gaon Pradhan is annexed with the additional affidavit filed on behalf of the petitioner on 30th of July 2024. Having gone through the said report and taking into consideration that the notices have already been served upon the respondent number 9, the service of notice upon the respondent number 9 and 10 be treated as complete. List this petition for admission after 2 weeks.
Item 4,
Yes,
Not only the part of lordship's order at page 26, para 7, and basically 9 and 10, madam.
Yeah.
My lord, here, I'm reading the 9 para, my lord. The learned single judge in para numbers 14 and 15 of the above quoted option of the portion of the MP on judgment has specifically dealt with the issue and come to the conclusion that the cases of those employees to whom promotion was granted are different from that of the petitioners in as much as the present petitioner passed the Group B training after coming into effect of the rules 2019, whereas the employees who have been promoted had passed the Group B training prior to coming into effect of the rules 2019. It's not correct. And their case for promotion was also considered for prior to coming into the effect of these rules. And therefore, the petitioner of WPC number so and so cannot be treated as similarly situated to those employees. It is an admitted position that the appellant passed the Group B training after coming into force of the rules 2019, whereas those employees with whom the appellant is claiming parity have passed Group B training before enforcement of the rules 2019. It is also not in dispute that their cases were considered for promotion before coming into force of the rules 2019. The appellant admittedly had not passed the Group B training and had also not acquired graduate qualification before coming into force of these rules 2019. Here, Lordship will find in my para 3 of this review, I have clearly mentioned the fact in table so that it will be distinct to understand para 3 para 3. The table has been made yes, I'm just reading out the para 3 that the review petition that as decided in point number 14 and 15 by the Honorable Single Judge as well as the Honorable Division Bench in point number 8 and 9 is not the correct fact on the basis of record documents relied on by the appellant petitioner, for which the appellant in writ appeal number F it was specifically urged that the single bench committed wrong as the promote private respondent number 12 to 16 pass out the Group B training on 16/7/19 and 4/11/19. That is after the rule came into force, and promoted on 31/12/19. That is after operation of the new rules 2019, that is with effect from 13/6/19, but not the earlier. It is stated that the review petition appellant passed the Group B training on 6/1 so and so. Now, Lordship, his seniority was also fixed at serial number 89, this petitioner's of the gradation list. Whereas this private respondent's Lordship will find serial number 1, private respondent number 12, Samuna Thakuria, promoted on 31/12/19, and he passed the Group B training on 16/7/2019. That too repeaters, not having any good career.
Provided this detail before the learned single judge or before us.
No,
At
that
time you are
part
not
also we
research
have
this.
that part.
It is not the case that you are not in knowledge of these facts.
No, that part also we enlightened, but that fact has been, we have specifically stated
Sir,
in
no,
the,
you should have come specifically whether by challenging the learned single judge's order.
that,
You should have mentioned in the appeal itself.
yet I have also mentioned in the appeal itself.
Appeal may simple, you have given this much of details.
Yes.
Where is that?
In-
Show us in appeal that you have given such much, so much of.
In
details.
the appeal, Lordship will find
Yes.
page 43, Lordship. B,
Yes.
Mary Lord. For that, the Honorable Single Judge also failed to appreciate and to consider the grievances of the petitioner on the ground of discrimination. In para 14 and 15, it was wrongly placed the fact that the respondent had already acquired the essential qualification of the passing B group training. The respondent number 11 to 16 were eligible after the amended rules 2019, that is on 16/7/19 and 4/11/19. And they were promoted by notification dated 31/12/19 with old rules 1963, though the new rules 2019 was under operation with effect from 13/6/2019, which is liable to be interfered with. That was before the Honorable Division Bench, madam.
Yes. What do you want to say?
At page 81, Lordship. 81, this is the prayer made in the read petition, Lordship. 4 prayers were there, A, B, C, D.
81.
Page 81. So Lordship, B is the prayer in respect of the private respondent.
Just tell me. 81 of the
Review petition, Lordship,
review petition, no?
the present petition.
81, yeah.
Lordship, prayer B. Set aside was the promotional orders of private respondents, some private respondents. But by this order, Lordship, I kindly see it order dated 14/12/2023 in the writ petition, Lordship.
Yes,
Second paragraph, the writ petition is filed with multiple prayers. However, the learned counsel for the petitioners has submitted that the petitioners will confine their prayers to prayers A, C, and D only. Accordingly, learned single judge preferred not to touch the private respondents, Lordship. That was the reason, Lordship.
no, but the learned single judge has given this reason that he can't claim parity with those persons to whom the promotion was granted because they acquired that qualification prior to coming into force of the
Lordship,
pertinent rules.
to that point, I have my explanation, Lordship. Although they passed in the year subsequently, Lordship, but they appeared in the previous batch. Their results were in the subsequent year, Lordship, appeared in they were in this petition, the private respondents were of the previous batch than that of the petitioners, Lordship. That was the reason, Lordship.
The notification itself clear, my lord. Lordship will find the clear notification, my lord. When they pass the,
Mr. Chetri, when are your clients retiring?
this 31st of October 2024. And this the Honorable Division Bench on the same way, my lord, same thing, my lord. This Honorable Division Bench passed an order, my lord, considering all these aspects, that since
Mr. Chetri, your review petition is on the ground that the division bench order which says no parity can be claimed is erroneous. That's the ground. According to you, the private respondents had also acquired the eligibility for promotion after the 2019 rules came into force, like your clients have. So, like your clients have.
yes, along
So,
with my client.
Listen. So therefore, same treatment ought to be given to both of them. But this aspect of the matter was debated in the first round when the order was passed, when Mr. Nayak had pointed out, which I remember, that the private respondents, their process of promotion was started before the 2019 rules were notified. But it was concluded only at a stage, by that time, 2019 rules were notified. So that aspect of the matter was taken note by the division bench and an order was passed.
Yes.
So where is the scope of review here?
But order is passed, my lord, here, my lord, since they were not qualified prior to the coming into force of these new rules, my lord, they were not qualified.
So then you challenge this order. That's not a ground of review.
No, but since, my lord, here, the review is, my lord, since the factual point is this, my lord, that as per this ground number 8 and 9, madam.
Yes,
9 and 10. It has been specifically stated that they were passed prior to coming to force of these new rules. This is not the correct.
This is not correct.
This is not correct.
But
And-
they were eligible, their process was started under the old
No.
rules.
There are forces, my lordship kindly have a look at page 241, the notification, my lord.
yes,
In the notification that 16/7/2019 they passed along with me, my lord. Lordship have a look for a time, my lord. 241, my lord. Everything will be clear, my lord.
yes,
The my serial number, 16 July 2019. Now, the following senior administrative assistant of the Janata Bhavan Assam Secretariat who appeared at the departmental examination of Group B training, 41st batch, held on 6/5/19. The examination was held prior to that, madam. 6/5, 7/5/19, and 8/5/19, and 9/5/19. I also appeared. And accordingly are declared to have passed the said examination under Rule 24 of the Assam Secretariat Subordinate Rules, 1963. If it is taken, these dates are taken, then my case is also prior to the coming into force of these rules.
no, you appeared in that selection process?
Yes.
No, on that day, before that, you were not appeared in that. Before coming into the force of the new rules, you have not appeared, those persons were appeared.
No, my lord, no one appeared, my lord.
That is the-
Simply,
that
they
is the
have just chosen.
specific stand.
Now, lordship, kindly have a look, my lord. Two notifications, my lord. This serial number 4, Dhirendra Patwari, my lord. And the private respondent, my lord, here, serial number 10, my lord, Lavanya Kumar. And our lordship kindly have a look at serial number 29, 30, 31, 33. They are also the private respondent number 14, 13, 16, and 12. Now, apart from this, my lord, another notification. This is 243, lordship, kindly have a look, my lord. Next page, my lord. This notification, they have passed on 4th of November 2019, my lord, after about 6 months. After about 5 months, my lord. This serial number 10, Haricharan Daimari. He is much more junior to me, my lord, as per the graduation list. And 25, my lord, Hasina Begum. They passed in November 2019. My lord, how this? All the
Yes,
on, only they are saying, my lord, this extended DPC not for these persons, my lord. The other persons are there, my lord.
yes,
Lordship, have a looked, that is their DPC, my lord, last DPC, my lord.
yes,
What they said, my lord. Page 246, my lord.
yes,
Minutes of the meeting of the selection committee held on 24/12/19 at 4 p.m. in the office chamber of the Chief Secretary, Assam, so and so, so and so. Now, lordship will come to the paragraph, my lord. The meeting of the selection committee was held on 24/12/19 at 4 p.m. under the chairmanship of Sri Alok Kumar, IAS, Chief Secretary, Assam, in his office chamber for recommendation of candidates for promotion to the cadres of Deputy Secretary, Under Secretary, Superintendent of and Secretary Service as an extended session of the meeting of the selection committee held on 4/6/19. Not only for superintendent, other officers, my lord, this extended service, extended session of the DPC, my lord. That relaxation, the meeting has been held to consider increase in vacancy following relaxation of required qualification in respect of under secretaries for promotion to the post of Deputy Secretary and subsequent vacancies. That relaxation has been made to the under secretaries to promote to the Deputy Secretaries. Only my case has been left out, my lord. Now, apart from that, my lord, lordship, kindly have a look to 247, my lord. 247, superintendent, my lord, C.
yes,
I have to be promoted to the post of superintendent. The member secretary apprised that at present there are 10 existing vacancies and another one vacancy would occur due to retirement of one incumbent on 31/12/2019 and 11 vacancies would occur due to promotion of 11 incumbents so and so and so. There are altogether 22 vacancies to be filled up in cadre of superintendent of the following cadre. Now, unreserved 9, STP 4, STH 8 and SC 1. Whereas my lordship will find the respondent number, the serial number 4, STP 1, 11 STP, 12 STP, 13 STP, 4 STP, but whereas 5 STP candidates have been promoted, madam. Here it has been said 4 STP. Now, my lord,
You have given up your prayer for challenging the promotion to the respondents. Now, how you?
yes, I have challenged this, some of the respondents, my lord.
But you have given up that prayer in the
Yes.
repetition.
Yes,
So now how can you argue all these?
my lord, this,
You have already given up that prayer, challenging the promotion of the private respondents. And now you are again raising this. This is what the Leonard single judge has said.
no, since I have come in the review petition, my lord, this.
Sir, review petition,
4 and
you are trying to
5.
argue the matter on merits.
My lord.
Afresh on merits. That is not permissible in the review.
I'm not on that, my lord. This
You
4
are on
and
that
5
only.
is totally wrong, my lord. This, whatever the fact has been asserted, my lord, that is not correct.
Fine, okay.
And only in this occasion, my lord, I would like to appraise before lordship, my lord. My lord, since as a whole, my lord, there is a the whole prayer is for relaxation of the persons who has only higher secondary qualification, my lord.
Fine.
And that part, my lord, since there is a provisions, my lord, in the rules itself, Rules 16 itself says that if a person or the employee is facing hardship due to the new rules came into force, then their cases should be considered, my lord. My lord, here the person is going to be retired. And that is why, my lord, in this point, my lord,
Yes.
our division bench high court, my lord, the division bench of this honorable high court, in the same issue, my lord, it has been held that when the rules came, my lord, some academic
Sir,
qualification has been added.
Again, please, Mr. Chetri,
Lordship.
what we are saying, that for the purpose of this review, you can't argue the matter again on merits.
My lord, that review,
On the face of the record is to be.
no, my lord, only thing is this, since this whole petition, this writ appeal was, my lord, disposed of on the basis of this, point number 8 and 9 and 10, my lord.
Yes.
So that, if that point is otherwise lordship will consider, then certainly I have a point to raise this fact, my lord.
Fine, be clear.
And that is why, since this honorable
review
court,
petition is filed by the petitioner seeking review of the order dated 6/6/2024. Passed and writ appeal number 127 of 2024. Good stop. Has submitted that that this court has failed to take into consideration the fact that some of the private respondents who have not acquired the requisite qualification prior to coming into force of the Assam Secretariat Service Rules 2019 have been promoted, ignoring the claim of the appellant. The claim of the review petitioner. It is submitted that the division bench has recorded a incorrect finding to the effect that the persons who were granted promotion have acquired the qualification prior to the coming into force of rules of 2019. Though the 2019 could stop. It is submitted that the said factual aspect has been clarified by the appellant in his appeal, specifically in para number 8. Para number
8, 9, 10.
Eight,
It's 7, 9, 10 laws.
7, 9, and 10. But the same has not been taken into consideration by the division bench. Would stop. Having heard the learned counsel for the appellant, we have heard the learned counsel for the appellant. As a matter of fact, review petitioner would stop. As a matter of fact, the argument advanced by the learned single, by the in the writ appeal of this effect has been taken into consideration by this court. And thereafter, a finding was recorded to the effect that some of the employees who have not acquired the requisite qualification before coming into force have been provided, have been provided promotion, but it has also been recorded that in their cases, the process, the process for promotion started prior to coming into force of rules of 2019. Would stop. The counsel for the writ petitioner attempted to argue the matter again on merits, but we are of the opinion that the again on merit which amounts to a re-hearing. However, the same is not permissible under the review jurisdiction. In such circumstances, we don't find any case for review. The same is therefore dismissed.
Item number 8 for hearing.
Petition. There are 21 and 22.
This factory is operating now.
Yes.
You're running it.
Yes, yes.
And
In
what
fact,
is
the
the
entire payment is made.
entire,
Entire payment, 1 crore, something was there that has already been made.
so this is an appeal for
There's an
refund.
appeal against the judgment and order passed by the learned single judge.
What is the average consumption now in your factory
At present,
at present?
that will need instruction for that. Not everyone.
At that
But,
point of time, what was the
Yes, your lordship will see annexure 1, page 54 to 57. Please make it
Yes.
54.
Yeah.
Your lordship will find there were, because when this happened, barely 3 months, we had not completed even 3 months of our operation.
Simply started in December or October something,
8th of October.
8th of October.
8th of October 2014 we started. And one day before completion of the 3 months on 8 only rather, on 8th of January 2014, they raided my factory. And it's a complete, I will demonstrate my lord, complete case of mala fight.
Right against.
They had, in order, my lord, in order to save their own skin, because the transmission loss cannot go beyond 3%. Here, the transmission loss was 19%. And they had to find some scapegoat. So they made all these stories that I'll my lord, demonstrate here from the records. I'll not say anything on my own. It's their own record that from there I'll show.
So they made this raided your factory only or some other also?
No, only me. There were 20 factories where I was singled out for this treatment.
Yes.
May I proceed if your lordship permit me? My lord, the petitioner, my lord, is
Yeah.
the petitioner is a partnership firm and it carries on business, my lord, of manufacture and sale of ingot iron from the scraps, my lord, heavy or light scraps. The total connected load is 2,950 kilowatt, which is equivalent to 3,500 kilovolt ampere kVA. The line to the petitioner's factory was charged on 1/10/2013, my lord. 1/10/2013, the line was charged.
Total load from where you were indicating this?
Yeah.
This I'm indicating from para 3 of the writ petition.
No, here connected load on 2975.
Yes, that your lordship has just seen annexure 1. There it is mentioned, the connected loads.
2975.
Page 55, it is there. Page 54, your lordship will see connected.
Yes.
Well,
Connected load in KV. So
2975. And kVA is 3,500. When the kW is divided by 0.85, we get kVA. My lord, the petitioner was aggrieved by the final assessment order dated 21/1/2014 made by, my lord, the area manager who is also the assessing authority. And my lord, the petitioner challenged that by filing an appeal. The appeal was dismissed. As a result, the petitioner, my lord, the appellant before your lordship filed a writ petition. The writ petition was also dismissed, and that is how we are before your lordship. My lord, the challenge is on the ground
that no case of either theft of electricity or unauthorized use of electricity is made out from the records. I'll take your lordship through the inspection report. Well, this is the beginning. Inspection report is very important because all the facts are discovered by making inspection, by inspecting teams, which consists of the area manager or the assessing officer. Your lordship will kindly turn to paragraph 4. Annexure 4, page 60. My lord will kindly come to G on the left side. Seal particulars. Your lordship get note. Meter cover found cracked, paper seal broken. Meter terminal cover, TC is terminal cover, cabinet box found intact. This will be important, my lord. I'll base my case on this. CT secondary not checked, optical port found intact. So what they found was there was crack on the meter box and paper seals were broken. Paper seals are just, it's a piece of paper which is pasted on the meter. It can, and the meter consists of about 8 to 12 seals, which I can show, my lord, from the next page, the photo state copy of this. This is type copy. The photo state copy of the inspection report. If your lordship will see the seal particulars on the right hand side, I could count. There are at least 5 seals, my lord. Your lordship will see.
Page number 61.
61, my lord. On the right hand side, I have shown, my lord, left hand side, seal particular. On the right hand side, your lordship will see.
New seal particulars? Yes.
See, yes, my lord, seal particular.
Seal particular.
Yeah. Then my lord, just parallel to this, new seal particulars. They took away the meter and put another meter and put this seal. So your lordship will see, I literally counted, my lord, 5 from here, seals. So it's not that there are only paper seals. They are wire seals and paper seals both. So out of which what they found was that the paper seals were broken and there was crack on the meter. This is what they have found. Now, if your lordship, I can proceed, my lord, further. General remarks on observation of testing and inspection. This your lordship will kindly see. As per telephonic communication of AGM, MED, the installation of Shamspat is visited to check the metering system. On physical inspection of the meter, both lateral side paper seals have been found torn. Also, cracks found on the right side of the meter cover. This is important, my lord. The existing meter is tested on load with ACCU check. The meter was tested on the spot. Percentage of error found within limit. So there was no defect with the meter. And on this, my lord, I'll make my submission. By showing your lordship, I have, my lord, brought ACCU test. What is ACCU test in my compilation, which I'll be handing over to your lordship. And also, what will be the effect if the meter is functioning within the limit, permissible limit? These limits are fixed by the Indian standard. So if the meter is functioning within limit, then it cannot be said that the meter is malfunctioning or meter has been tampered. That will be ruled out. That I will show their own regulation to that effect. CMRI taken for computer analysis. The meter is seized and properly sealed in presence of the consumer representatives and taken to T&C lab for further investigation. The old meter is replaced by the new tested meter. And after changing the line, all meters parameters were checked, found okay. Meter system is sealed by TNC. This is, my lord, their lab, which is transmission and commission lab, laboratory, which they call TNC, as recorded above. New meter security bill is to be raised and served to the consumer. So there are three things, my lord, here. Number one, only paper seals were found broken, 2 paper seals, and there was crack on the meter. Then when they tested the meter, they found that it was within the permissible limit. This is the unique. This is the Your lordship will isn't like. I'm sorry, my lord, you did not hand over the paper.
Yes.
My lord, kindly turn to page 85. The rules of India, 1956 rules. Yeah.
Yeah.
And she got a lot. ACCU check HT is high transmission, is designed to test high tension meters. It is a systematic check facility which ensures detection of circuit faults. So this is on this, they have checked the meter and they found that the meter was functioning, my lord, within permissible limit. Now, if my lord will come to page 23, this was the earlier law. This has changed, but it will have no material effect on this. Your lordship can kindly turn to page 23. This is the Indian Electricity Rules 1956. 1956. The relevant is at page 25, Rule 56.
Yes.
Rule 57, I'm placing at page 25. Meter maximum demand indicators and other apparatus on consumer premises. Any meter or maximum demand indicator or other apparatus placed upon consumer premises in accordance with section 26 shall be of appropriate capacity and shall be deemed to be correct if its limit of error are within limits specified in the relevant Indian standard specification where no such specification exists. The limit of error do not exceed 3% above or below absolute accuracy at all loads in excess of 1/10 of the full load and up to full load. So it will be deemed to be correct. This is my lord, a deeming provision, statutorily deeming provision provided by the statute. So it will be deemed to be correct. Now, this, my lord, continued, I'll say till 2006 regulation was made. Because if your lordship will kindly have the act, section 185, 2C.
2C of
2C of section 185, my lord. If you are holding, my lord, same book, it is at page 109. Section 185, repeal and saving.
কিমান ক'লে তাত?
185.
yes.
C says, my lord, the Indian Electricity Rule 1956, made under section 37 of the Indian Electricity Act 1910, as stood before, such repeal shall continue to be enforced till regulation under section 53 of the Act are made. Now, they have made a regulation in 2006, although they don't write section 53, but yes, it is for installation and operation of meters, so then I agree that it will cover. I have annexed that, my lord, in the same compilation, and your lordship may get, my lord, at, what is it? Regulation, my lord, at page 6 of the compilation. 6 of the compilation.
Yes.
My lord, may kindly come to definition of correct meter, section 2K. This, my lords, will get at page 7.
Yes.
Page 7. Correct meter. My lord Scott.
Yes.
Correct meters means a meter which shall at least have features, accuracy, class, and specification as per standard or installation or operation of meter given in schedule of these regulation. Now I'll take your lordships to schedule, page 7B. Page 7B. My lord will see 7B.
Yes.
Standard reference, I'm saying specification of meters at page 7B of the compilation.
Yes.
Standard reference voltage as per IS, that is Indian standard. Voltage range as per Indian standard. Stand frequency as per Indian standard. So everything Indian standard, nothing has been changed. And that is why they say that the meter, when tested on ACU check, it was found to be within limit. This is their case. Then I'll just refer at page 7A, just the previous page, if my lord will see. 7A, just before one page below. Standards. All interface meter, consumer meters, and energy meters, accounting or audit meters shall comply with relevant standard of Bureau of Standard, BIS. If BIS standards are not available for particular equipment or material, the relevant British standard or International Electrotechnical Commission standard or any other equivalent standard shall be followed. These are all everywhere, A and B, it is mentioned below. So what I'm trying to place before your lordship, submit before your lordship, that their own case that my meter was functioning within the permissible limit. If that is the case, then that there should have been no controversy whether a case of theft or a case of unauthorized use of electricity is made. That should have been the end of the matter. But it would not have ended for the reasons that the transmission loss was 19%. I'll show from the record. Transmission loss was 19% in place of 3%, and some scapegoat had to be found, and they found me.
That was not the case before the learned single judge.
My lord?
That was not, this point was not at all addressed before the learned single judge. That there was malafide on the part of this.
But it is there in the writ petition.
But ultimately, it has to be reflected from the order.
My lord,
Any such argument was made or not. That was not there.
many things your lordship will find that may not have been raised. I'm saying, but at the same my lord, breath, I will also, my lord, very humbly say, that submit with your lordship, that this will be a question of law. Whether their own papers, documents, when it says that it is within limit, because learned single judge, my lord,
That argument was very much there. But so far as regarding this Mela-files, that on account of this 19% loss, they have implicated me falsely or whatever it may be to cover up that loss.
But-
That argument was not there. That,
my lord,
yes, you said
yes,
that initially there was no evidence and later on the appellate authority has read on some piece of evidence which was collected later. This is what the argued before the learned single judge as reflected from the impugned order.
I'll not dispute that, it appears. I'll not dispute that. My lord, I can.
Is it there in the pleadings before the
Yes, yes.
single judge?
It is there.
Nullified?
It is in there.
Okay, can we just,
It's not, my lord, that way it is modified, it is not there. He says to save himself and to implicate me, this has been done. The very word modified may not be there, but
no, but then let us accept that malified word is not there. But
What?
if there is an allegation against someone,
yes,
that
yes,
has to be
I'll
decided,
show-
that
I'll
person
show.
has to be made a party.
I'll show.
Where is it?
My lord, area manager is a party, not by name. But my lord, malified, malice in law can always be attributed. Malice, in fact, my lord knows that right from when malice of fact comes, my lord, I remember that Pratap Singh Caro case. That's one leading case on malified, where the personal doctor of Dr. Caro, my lord, if I'm correctly, I remember, produced all the chits and not accepted by the Supreme Court. So, my lord,
You're right. Malice in law can be urged if the materials are there.
yes,
But as you know, there are very well set parameters to assess what is a malice in law.
yes, yes.
The action has to be rampantly in violation of established
That's what I
norms and duties.
will show. I will show the violation. I'll show the violation.
Passed by statute.
Yes, yes.
There should be
Yes.
violation of statutory.
Yes, it is there. I will show, my lord. My lord, I can, my lord, I will show, my lord, that it is violation of all the law, all the statutes.
Right, but then that is not malice in law. That to save his skin, he has targeted me,
That-
picked me up.
that-
That's not malice in law. That's factual malice.
That, of course, but
That
it
cannot
can
be
be, it can be inferred, of course. It can be inferred, but let me not go, even if your lordship leave this for a second. Then also I have a case, because no case is made out. Like I always say, because learned single judge, my lord, proceeded on the premise that tempering of meter is admitted. This is paragraph 16 of the learned single judge's,
Not admitted, established.
no, admitted. The word is admitted. Because there's no question of any establishing. There is none, first.
Yeah, Mr. Kejriwal, where is the pleading in your writ petition? Which paragraph?
Writ petition is at page 108. 108.
Which paragraph has it been ever?
Tell the court.
Same there.
That's 19%, that one you show. On page 20, paragraph 28, if your lordship will come, page 127.
28.
I think page 127.
Page 127.
Page 127, the last paragraph, 28. Now, the petitioner states and submits that it was only after receipt of the appellate order dated 8/9/2014 for the first time, the petitioner come to learn that inspection dated 8/1/2014 in his premises was carried out because there was loss of 19.11% in 33 kV something Chhatribari feeder in the month of October and November 2013. As the petitioner was solely responsible for alleged as if the petitioner was solely responsible for alleged loss in question, although about 33/111 kV feeder provides electricity to 19 other consumers besides the petitioner. In this connection, the petitioner states that the alleged loss may be attributed to high transmission loss in providing electricity to 20 consumers on account of unauthorized sale of some wasted circle or leakage of electricity. It is submitted herein that petitioner being a new consumer, the authority thought it best to make it scapegoat and recover the alleged loss sustained by it. The entire exercise right since the inception.
As per the petitioner, he came to know when this appellate order was passed, that this may be the reason for that.
For raiding his premises.
In the inspection carried out in January.
Yes.
And in September, you came to know about all these cases since you were the new customer.
Yes.
To save the others.
Yes, because on that date, my lord, nobody will tell me that we are here because there is a loss of 19%. These are because, my lord,
Till September, you were not aware. After this appellate authority has passed the order, you came to know about this.
Yes. Yeah, I was not aware because I'm not privy to that. So, my lord, I was on, when I continue, my lord, with my lord, what I submitted before your lordship, that they themselves found that the meter is functioning within limit. Now, therefore, I ask a question to myself, where is the question of tempering? I'll temper the meter and the meter will still function. Just a question that I'm asking myself.
No, Mr. Mishra, we are sorry to point out, what you are proposing perhaps does not arise. Their allegation is that the meter was normal, but by removing the seal, you have installed an external circuit. Just a minute. Which was done to show a lower consumption, reduce the consumption, and this was done stealthily. So when they went for the inspection, having realized that the reading was far less than what is the connected load capacity, they found two things. Number one, that this is the allegation. We are not saying it is established. Number one, that the paper seals were tampered with, removed. This is their case.
Paper seal, yes.
Just their case.
Yes.
Then they found through analysis, through computer analysis, etc., that there was evidence of external circuit having been fitted into the meter. But otherwise, they said that the meter was not functioning. So the fact that the meter was okay does not absolve your client of the allegation.
It is not meter, it is functioning of the meter.
Correct, meter is okay.
All right, and if some external thing has put in there, and your lordship pointed out.
No, that's their allegation.
The allegation, my lord, this is finding of the learned appellate authority. This was not even found in the TC lab where the meter was tested by order of the appellate authority. I'll take your lordships through that.
But in page 60, they have mentioned it in the.
I will show, my lord. I will show your lordship. I can straightway take your lordship to, because what has happened in the before the appellate authority is, my lord, fantastic to say the least.
No,
I'll show.
We will hear your arguments, Mr. Mishra.
Yes.
Just
kindly come to page 90 for a second. 90.
Give us a little insight into just two things. We'll hear your argument.
Yes,
We are just pointing out what is the projection in the.
yes, yes.
First of all, what was the amount raised in the bills during the period during which, according to them, there was external circuit and tempering, etc.
Yes.
And what was the bill which was raised immediately after it was detected? Can you give us a, because it is the same
After,
factory.
what was after
Hmm.
that, what was after, because I have annexed only annexure 1, which I have shown to your lordship,
Yes,
page 54 to 56.
all right. That
This
is
is what I
after,
have shown.
that is just after.
Yes. One is before, of course.
54 is before,
Yes, my lord.
55 is also before.
Yes. It is, one is, yes, the last one is 1/1/2014 to 18/1/2014. 8/1, sorry, at page 57. So this also before the inspection. But definitely this is the period where in the allege that we put external.
We wanted to see what is the difference in the electricity consumption if their version is to be believed.
Correct.
Mr. Goswami, where is that figure?
You get those things.
You don't have it.
It's the difference to assume that there was
Difference in.
certainly that was a difference, that there could be, there should be a difference between the.
That will be the most fundamental point, and it is not there on record. If there is no difference, then all your stories will be doubtful.
Before the inspection, if the consumption was suppose 10,000 units, and after inspection, also it's almost same or here and there a little bit. Then
We must have it. That was never a point period, so we had the option to proceed with the controversial. I can definitely get that.
Then this action might be hit by vice of irrationality. You have said everything else.
Midway, I will proceed.
That will also depend on how much hour the factory is working.
That will depend on various factors because we use light scrap and also heavy scrap. There will be some difference. Here also there is some difference.
No, Mr.
But your
Mishra,
lordship, what is saying
what-
is,
what we are trying to see, please understand.
my lord,
There are a lot of, you are entitled to argue, you please argue, we'll hear you. But there are a lot of hypothetical aspects which are being brought into.
Yeah.
You know how the REIT court will deal with it.
Yes, yes.
So let us cut the long matter short.
Yeah.
Let us see what are the established rational parameters, and looking through the prism of those parameters, let us try to assess how far the allegation is acceptable.
Absolutely.
Otherwise, what happened, how a meter looks,
No,
how
no,
it
I
should be,
will.
we cannot
Yeah,
obviously.
this is just a point that I have said. That if it is functioning all right, then it can, I mean, since your lordship, by going through their version, your lordship says that the foreign circuit was there.
The
Now,
reason
if your
is,
lordship hear me,
no, correct, we'll hear you.
yes,
But the reason is the material facts, the chain of material facts will be completed if they show that, look here, by this tampering, putting an additional circuit, this is the amount of electricity
yes, yes.
they were
Absolutely.
hoodwinking
Your
the
lordship-
APD cell.
But that-
That
the
is,
satisfaction
that
of
is
your
an important
lordship,
material
yes.
fact, they will have to give it.
Yes. Now, where? Did I miss? Very.
इस बैच सिस्टम में क्या होना चाहिए? तब क्या थी ये बात कस्टमर का कोई डिसीजन लाइक हमने सवाल
उन्हें नहीं
want to say something?
What is fallen from your lordship is absolutely the perfect way of looking into the authorized use of electricity, madam. With due respect, madam, under section 126, entire proceeding goes on under section 126. Authorized use of electricity has also been defined as use of electricity through a tempered meter. If a meter is tempered, madam, everything gets established. Madam.
Mr. Goswami, let me point out one thing. We are not saying it has happened here, and we may not at all say it, but we are conscious of the fact that just because some provisions exist here and there could be attempts to exploit these provisions and extract
That
some
can be
money.
abused, madam.
That cannot be ruled out.
True, madam.
What we are asking you is, where is your initial material fact? Your material fact has to be that this is an heavy consuming industry. There was a meter fixed. We found that it was tempered. There is evidence of a circuit. By doing this, this is how they have stolen electricity. When we rectified the situation, the consumption shot up to this. There is no change in the factory consumption parameters. So this is a clear prima facie evidence that they had tempered the meter to.
That details, madam, I will definitely bring.
Where is that material fact? If that material fact is not there, then you can't say that now you pay us, we'll see what evidence we can get later on. Whether who has done what is not the point. Point is whether the allegation has been established. That's the only thing we are going to see in a writ petition.
But there was an allegation, my lord. There was an inspection.
Yes.
To the extent of finding a tempered meter.
Where is the link?
To the extent of finding a tempered meter is there, my lord.
That's
Definitely.
correct. But
Thereafter, my lord.
thereafter also the consumption remains same. Your case will
My
fall
lord, allows
flat.
me some time. I will
Your
get,
case will fall flat.
I understand, madam. My lord, allows me some time.
Can't be.
I will
It
get hold of
cannot adopt an irrational approach.
True, madam.
Rationality is the fundamental, the hallmark of this. We don't know how a meter is to be tested, how it looks like. Mr. Mishra has the expertise. He has got a very able assistant. We can't go into all
In
these
that way,
things.
my lord, we all have to be electrical engineers, my lord.
No, no,
Difficult.
that is the advantage that
My
they
lord,
take.
My lord, kindly appreciate
And
one
they abused 126 and 135. Kindly see, my lord, section 145 of the Electricity Act. 145, 175.
my lord, this is a
Law-
certiorari.
Your lordship, I will
Law
just
is
show-
meant to be abused for
No.
those who can manage it.
Yes. My lord, 145, your lordship will kindly see. Yes, what I'm asking for. Hmm? No, 145. Section 145, your lordship will see for a second. 145, your lordship will see for a second. Section of the Electricity Act. 145.
Then why don't you give us this, both of you give us these particulars,
Yes, I'll bring them.
Mr. Mishra?
I
In
will
the form
surely.
of a short affidavit.
Yes.
We'll not go here and there. We'll just see.
No, my lord, that's why I wanted to take your lordship through 145. The jurisdiction of the civil court is barred. The only
That-
remedy,
Yes.
permit me just a
Yes.
second. The only remedy we have is by way of a writ petition. And it is not that your lordships cannot enter into disputed question of fact. First of all, there is no disputed question. But suppose there is an allegation that we have tempered. Don't we have right, my lord, I'm asking myself, to say that no, we have not. And by saying that, they say, no, this is a disputed question of fact. Who will go into it? Your lordship will see right from Beena Pani to B.M. Patel to Johari Mal. Your lordship, I'll place all those.
Mr.
But I'm
Mishra,
saying, yes,
we are not trying to interfere when you are arguing,
my lord,
but see, what you are saying, these are well established. But you say you have not done, he says he has done, you have done. What does the read code give a finding? That it has not been done.
Writ code will go through the records.
That's what we want.
Yes.
Where is the evidence to show what was the consumption immediately after?
First of all, your lordship may look into where is the evidence of temper of meter, whether what they are alleging is correct. Prima facie even prima facie, my lord, I'm saying. Permit me to submit.
All right. So, what is your stand? Is it necessary to have those particulars or not?
No, your lordship may have that particular.
Then
It will be
we'll
better.
defer it by a week.
It will be
Both
better.
sides
My
present.
lord, I will not, rather, it will be better. It will establish.
That's what we are
something.
saying.
Yes, it will be better.
That I will bring, my lord.
No, by a short
Small
affidavit, we don't get.
Affidavit.
Small submission, my lord. I will bring that on record, my lord. Page 54 is their bill for the month of November 2013. It was around 12 lakh something. Next month, my lord, it was 18 lakhs. And the month on which it was inspected and it was found to be tempered, my lord, it came down to 4 lakhs.
4 lakh.
On the date when the inspection was done, by 8/1/2014, this is the period from 1/1 to 8/1. Right? No, my lord, it's shorter
7
period,
days.
shorter period.
It is there.
Mr.
I'll get the
Goswami,
details.
don't rush into. We
I'll
are,
get that. details, my lord.
we are saying something after some amount of thought, application of mind. Don't rush into anything.
I'll bring everything on record.
Mr. Mishra, you want to continue? You can.
I leave it to your lordship, my lord.
First of all, bring that, the details.
Leave it to your lordship.
So we'll fix it on Tuesday. Bring it on the detail, Mr. Goswami and Mr. Both.
We'll file a short affidavit on Monday, or let it be on Thursday, my lord.
Thursday will be
Affidavit.
8th of August.
जाना है ना 13th August. So we do it then 13th August. Thursday there is some problem.
My lord.
13th August. You have some difficulty.
Some difficulty. If your lordship can take it up on 50 or 15.
15th August, all of us have some.
Yes, on 20th.
20.
20.
All right.
It's on 20th.
Man. Unless we forget 15 August also.
15th August, we have something in the High Court. You must come.
Country-wise.
Mr. Goswami,
I understand.
an affidavit giving the 12 months bills to be sworn by a competent officer, you can give your version. We want to see what is the escalation, what is the upheaval, what is the downswing.
Because it's only 3 months before. So from that 3 months and subsequent.
They started operation in October and this was conducted in January.
So we'll say 6 months from commencement for product.
Yes,
6 months from.
6 months from,
Yes.
right from beginning to 6 months.
That may not be indicated because, my lord, there is a possibility after a detection, it was discontinued for some time, my lord.
How
Then,
much,
my lord, so that I will see, my lord,
how much time?
1 year, my lord.
1 year.
Shorter period, my lord.
Yeah.
Immediately after a disconnection, there may not be any bill, my lord.
No,
Because this might have
immediately
led
after
to
this
disconnection.
connection, when this connection was restored.
That is why, that fact is not known to me today, my lord. That's why
Okay.
Well, bill
we'll
since,
give for a longer period, my lord.
well, bill since commencement.
My lord. That will be better, my lord.
The bills after this connection was restored.
Yes, yes.
Yes.
After we paid 50%, it was
In
restored.
before the appellate authority.
Yes. My lord, I may just point one thing. Initially, they made out a case of theft of electricity under section 135. Then the general manager wrote a letter to them that you have made out a case of 135, but you have not filed the FIR. So you have to file the FIR. Now, the area manager made a manipulation. What he did, that consumer wants it to be under 126, not 135. So he made final assessment under 126. Now, your lordship knows whether yes, sorry.
মানে পোয়া প্রোডাকশন পোয়া ওয়ার্কিং হবে এখানে আগত প্রোডাকশন আর ওয়ার্কিং এনে লগা নয় এখানে মই বন্ধ থাকিব ইমিডিয়েটলি ফ্রিল্যান্সিং বন্ধ থাকিব পাৰে সব বন্ধ থাকিব খুব বন্ধ থাকিব
Twentieth of August.
Hello, the compilation that I have given to your lordship, I'll take it back and bring it again on the next date.
Yes.
Sometime
We
it-
made some markings.
No, then your lordship,
You
only
take
thing is, if it is there, sometimes it gets misplaced, my lord.
No, then we'll place it on our record.
That's it. Yes.
Item number 10.
Please, your lordship. Also, the petitioner here is aggrieved by the bank's action of enforcing their action under SURFACE Act, where the petitioner is neither a borrower nor a guarantor. In this case,
without properly verifying the credential of the person they have lended him money on the basis of a agreement to sell.
agreement for sale. This is the case.
What's your ma'am?
Exactly, sir. Your lordship, that is the thing, that in the year of 2006, when one Pranjal Bharali has applied for us for a loan facility. On the basis of that, he has entered into an agreement for sale. So gradually the building will be constructed and gradually the bank will grant him the loan. And ultimately, at the last, when the sale deed will be executed, the said mortgage will be created. But we have our security interest on that because he has executed the necessary document for the sale. And we have created the surcharge and other charges on the property. In the year of your lordship, then what we have found from the writ petition, that on 3/4/2007, the sale deed was executed in favor of the petition.
By whom?
By the same Pranjal Bharali. That is page number 9.
So he was not aware at that time that this property was mortgaged with the bank on the basis of this agreement to sell.
Yes, he is not aware of the.
He was not aware, so how he can be?
Your lordship may kindly come to page number. That is page number 19 of the application.
Yes.
Yes, sir. And your lordship may kindly see, number one, that the Pranjal Bharali, who is a borrower to me, has executed a sale. Now, second thing, that he has executed a sale deed only for ₹1 lakh. Whereas we have granted him a loan of ₹12 lakh.
Challenge that sale deed.
Yes, your lord.
Whatever it may be, challenge that sale deed.
Yes, your lordship. That is why I am submitting that my right to challenge, because section 53 will come into play of Transfer of Properties Act. My right will be preserved and.
So there is a question of preservation of right, it is always open.
Yes, your lord.
You can very well challenge that sale.
Yes.
Because the civil court, if that
Yes,
was a
and
sham
we have-
transaction,
We have also
challenge
had
that
a
sale.
decree of the civil court in the year of 2015 also. But unfortunately, I cannot bring it before your lordship.
you have decree?
Decree against Pranjal Bharali, your lordship, in which they are not the party. We have already obtained a decree.
Oh, he is affected for that.
I am not the party.
He is not a, but against the same flat, I think it may be attached in the learned court below. Because, but we do not have any record to place it before your lordship, so I cannot make a sum.
Then withdraw all these proceedings. And we'll grant you a liberty that if you can challenge that sale deed, you can very well challenge the same in appropriate proceedings.
Yes.
Withdraw it.
Your lordship, well, your lordship may kindly interfere with the, I do not have any, but for withdrawing the actions, we have to inform the head office and there is a lot of procedure at our end.
Well, it
I am
may
very
be-
sorry for that. I may be set at a liberty to institute an appropriate proceeding.
Right. But then you withdraw all these, whatever the action you are taking against it.
And your lordship, I have.
Mr. Sharma, your head office should be able to respond in next 15 minutes. You want a judgment in merit, we'll deliver, but then liberty is not guaranteed. If you want liberty, then you have to withdraw the proceeding, we'll give you liberty to go. So you have 15 minutes to, 15 minutes to take instruction. You tell your whoever, Calcutta or Delhi,
Yes.
that these are the two options. If we reserve and write a judgment, liberty is not guaranteed. You can't have the cake and eat it too. That's not possible.
Yes.
So think about it. After 15 minutes, let us know. Fine?
At two,
Yes,
come and inform.
Item 12.
I'll check it. Hmm? No, no problem. Hmm? Full. ডিপিটা কমপ্লিট হয়ে গেছে সাবমিট হয়েছে এই ফাইনাল রেলওয়ে রোডের কমপ্লিট সাবমিট আমরা জানি কি কিন্তু এফেক্ট নিয়েছে সাবমিট হয়েছে পেন্ডিং রেলওয়ে রোড ডাইভিংটা কত বুঝতে আছে দেখে দেখি
Is there any proceeding initiated against the respondent?
Yes, sir.
He has been found guilty.
No,
No, my lord.
my instruction is that. no.
After the order passed by the learned tribunal, they have issued a charge sheet. And the inquiry has not.
Have you challenged the charge sheet?
Sorry, my lord.
Is the charge sheet under challenge?
No, no.
Is the departmental proceeding under challenge?
No, 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 no. My lord, what is challenged before this honorable court is an order passed by the learned tribunal.
Mr.
sorry.
Das, please
Yes.
listen. If it is no, then they have a good case. How can you get all benefits when there is a disciplinary proceeding pending against you? If the proceeding is maintainable,
That is after the order. passed by-
maybe, but if it is maintainable, then the penalty could be withholding of your pension also under
That
the
is a
law.
separate proceeding altogether, my lord.
And what happened in that CBI case?
My lord, that instruction we do not have, but so far the inquiry is concerned, I just talked to my department. The inquiry is over. He has been found guilty. That is what I got instruction, and it is pending at the railway board for further course of action, my lord. But the issue before the learned tribunal.
দিয়ে দাও দিয়ে দাও দিয়ে দাও
Rule 9.
দুটো দিয়ে দাও সেটা কিন্তু এটা আপনার
My lord, this is the railway service pension rule.
Rule 9 is relevant here. 9(2). 2B. 2B.
And he is getting provisional.
Hmm?
He is getting provisional.
You have not challenged the,
My lord, I'm sorry.
just give a one-line answer. Don't go into history.
No,
Joe.
I'll not go, my lord.
You will not challenge.
The
You are not
charge sheet-
challenging the You've been found guilty in the disciplinary.
May I just explain one thing, Milord? Your lordship is correct. My senior friend is also correct that the inquiry was held after the order passed by the learned tribunal.
Yeah.
And in the inquiry, it was found, the charges are held to be proved. It was in the month of March 2023. Inquiry officer's report was furnished to me. I have submitted a reply to the inquiry officer's report. And since March 2023 till now, no decision by the disciplinary authority. Milord, that is a separate thing altogether. That is a consequential thing. What is challenged before this honorable court?
Release of terminal benefits.
Whether the pension can be withheld or stopped without holding any disciplinary proceeding, that is the issue before this honorable court now.
You are right. Now now please.
Change
Now,
circumstances. Yes.
change circumstances, since disciplinary proceedings are almost at the verge of completion against you, no final order has been passed.
For last 1 year.
From last 1 year, that's right.
Yes.
But since the order of this court has already been stayed, suppose tomorrow, if the disciplinary proceedings find that charges against you are proved and some punishment is required,
They
then
can always.
what would happen to
impose.
that?
They can always impose. Milord, firstly, Milord, I'll just explain one aspect of the matter regarding the charge.
It's better to wait for this decision of the disciplinary authority. And we'll direct them to take it.
Milord, may I just explain one thing, Milord?
Yeah.
So far as penalty after the proceeding is concerned, Milord, they can, Milord, impose penalty of withholding of pension or cutting pension, Milord. That can, they impose at any time. They were not required to stop my pension and other retirement benefits in the year 2020. Tomorrow, suppose they have found tomorrow, they have decided, all right, we'll impose some kind of pension, penalty under the pension rule. They will impose that penalty, Milord.
From that day,
Sorry, Milord.
from the day when the disciplinary of the.
But that is what I'm trying to just, Milord, without issuing any charge sheet, you don't have any authority to stop my pension. So the day I retired, you are. Because this penalty has.
Why don't you decide this disciplinary proceedings within 15 days, month? Take a decision.
No, already. Final. Final decision has been taken.
The final decision, you take the final decision.
That has to be prospective, with all due respect, Milord.
That-
I'm sorry.
Consider that.
My apology. My apology. My apology.
Milord, so far rule is concerned. We have, my instruction, my junior got the instruction, the department inquiry has been completed. And
So whatever the sanction or permission from the railway board, get it and serve the order. Do it.
sometime.
Okay. When it concept for the appellants, I have submitted that.
Each one event.
After passing of the impugned order by the CAT Guwahati, disciplinary proceedings were initiated against the respondent, and the inquiry officer has already submitted his report to the departmental authority. However, the departmental authority is waiting for the approval from the railway board. Full stop. When it concept for the respondent has submitted that, as a matter of fact, the disciplinary authority has already sent has already placed the matter before the railway board way back.
So the inquiry report was submitted in the month of March 2023.
But the inquiry, the inquiry report was before the disciplinary authority was submitted way back in March 2023, but till this date, no decision has been taken by the disciplinary authority to stop. Taking into consideration the above facts and circumstances of the case, we directly appellants to petitioners to finally decide the disciplinary proceedings pending against the respondent within a period of 4 weeks from today.
No, 1 month.
4 weeks or 1 month, what's the difference between them? 4 weeks from today. List this matter on 9th of September. 9th of September, so 10th of September. 10th of September, Tuesday.
One clarification, my lord, they have said crores of rupees, all those monies are were recovered from the contractor, my lord. No pecuniary thing is involved as of now.
Let them-
So there is no question of recovery, so gratuity cannot be withheld.
Depends upon the order passed by the disciplinary authority.
True, very true. Value.
Item 13,
10th.
May I please, Lordship? The matter may kindly be passed over for time being, Lordship. Senior counsel K. will argue. The lacking point number 4.
So
God bless.
item 15,
My lord, I'm praying for a little accommodation today, my lord. Let the matter be come up on 13th, my lord.
Lordship, there is some urgency in the matter. They have been taking time. I think 50 times they have already taken. So what? Actually, I am praying is that Lordship, can it be done in the next week? The 5th or 6th. There is some urgency in the matter. Lordship, this person has been, he is a principal there.
transfer matter.
Yes, Lordship, it's beyond the rules and regulations. He has been attached to the higher education department.
I think so the stay order is already operating.
Yes, it's already there. Lordship. So like we want some, because like this order is, I mean, totally wrong. Lordship. So as per the rules, he cannot be transferred and he cannot be attached. There is nothing in the rules.
What is the urgency for your client?
Since he is now he is attaching the as OSC in higher education department. He'll be retiring in couple of months, a couple of years also. Because like it's a single letter post also. It's a single letter post. It's non-transferable post. He has been
Thursday,
13, Lordship. 13, Lordship.
why 13?
13, Lordship.
What's the problem on Thursday?
Thursday, Lordship. Not Lord, there is problem among our mind.
Thursday, 8th of August.
Thursday can take point.
We'll consider that on that day. Whether his presence is required or not.
Lordship, 13.
Yeah.
13 Lordship.
8th of August or 13th. 13.
Item 16.
I'm led by senior counsel M.K. Sudhirmana. Today he has some difficulty. Let it come next week, any date.
Item 17.
17 lots in that day, indicated. Lots in the taken in the matter, 2 lots in. So he will be at 2 lots.
My lord, before that, my lord, in this case, my lord, I am leaned by Mr. Kane Sodri, my lord, senior counsel. He is in another court, my lord. He has some difficulties today, my lord. Kindly take up some other day these matters, my lord, if possible.
That too. We'll consider that too.
Obligation.
The other day also it was adjourned because of Mr. Chaudhary.
My lord, he has some,
State is expressing urgency.
my lord, I'll inform.
Hey, even this other matter, item number 13 is prayed for latent accommodation up to after lunch,
My lord,
in which all Mr. Chaudhary is appearing.
yes, my lord.
Now you are saying maybe adjourn for, let us see. And then we'll see.
Item 18.
Obligation. The other side is not there. Otherwise I can make my
What's for the other side?
Mr. S.C. Kyle lot.
SC Kyle,
Lot.
whether he's in town or not. He's here in the court. Pass over for the time.
Item 19 and 20.
Meet legal option. In this petition, my lord, we have challenged the virus of the rules 8, 10, 1, 10, 2 of the Assam Secondary Amendment Rules, my lord. By enacting this rule, the respondents frame the rule that my lord kindly turn to page 59. 58 is the rule, my lord, this amendment rule. Page 58, amendment of rule 8. May I read, my lord? 8.1. The recruitment to the post in the cadre of postgraduate teacher and graduate teacher, the petitioners hearing the graduate teachers, my lord, including subject teacher in vocational subject, shall be made by direct recruitment through the teacher's eligibility test, come recruitment test, hereinafter called as TET come recruitment test, to be held as per criteria mentioned in Schedule 2 and in a manner herein after provided. Therefore, also kindly turn to page 59. This is the amendment to Rule 10. Page 59, madam.
Yes.
In a principal rules in Rule 10 for Sub-Rule 1, the following shall be substituted, namely, the academic and professional qualification for direct recruitment shall be as in the Schedule 3. Number 2, in addition to such academic and professional qualifications mentioned in Sub-Rule 1 above, for direct recruitment to the post, all candidates shall have to appear in TET come recruitment test as per Rule 8 of these rules. And page 60, the Schedule 2 is there, my lord, where 250 marks have been allotted. For teachers eligibility test come recruitment test, 250 marks in the has been allotted, my lord. My lord, the petitioners herein are all the TET qualified candidates, my lord. At age 30th onwards, my lord, I have annexed the TET certificate, TET qualified certificates of the petitioner, and it has the validity of for 7 years, my lord. We have completed it in the year 2020. Page 30th down below, 23/7/2020, and a remark column lordship will
Mr.
find.
Decker, this is not connected with the special bench matters where The provisions of these amended rules are under challenge.
My lord, it is regarding, my lord, that new provincial, new rule 2018 that has been amended by way of 2023. It is related to secondary education rule, my lord. That matter pertains to provincialization, my lord. Here, my lord, this is direct recruitment. That 2018 secondary education rule, it has been amended. And page 38, these are certificates. The validity is for 7 years. The remark column lordship will find. That means, my lord, we have the that validity, that our certificates have validity till 27, my lord. What happened, my lord, thereafter? Page 61. Advertisement was issued by the Director of Secondary Education for filling up the post for the graduate teachers, my lord.
Yes.
The right-hand side, my lord, the criteria for selection of graduate teacher. First stop, my lord.
Yes.
Teachers eligibility test come recruitment test. So for qualifying, my lord, we have to appear once again in the TET, which we have already qualified in the year 2020, and our validity of our certificates is for 7 years. So respondents want
Teachers eligibility come recruitment test 140 marks.
yes, my lord.
The paper shall be 140 marks per degree, so and so, general correct.
Our grievance is this, my lord, since we have already qualified in the TET, so there should not be any requirement for us to once again we'll have to appear in the TET examination, my lord, which have already qualified in the year 2020. And my lord,
That's right. But how this rule is banned then?
yes, my lord. My lord, may I hand over this NCT regulation, my lord? NCT regulation prescribe the qualifications, my lord, of teachers and graduate and postgraduate teachers, my lord. দুটা দিছো লাগি আছে নেকি দুটা আছে we are giving 2 copies, my lord. ওইখান থেকে লটে গো Kindly turn to the next page, my lord, second page. Down below the notification, National Council for Teachers Education notification. In exercise of powers conferred under clause DD of subsection 2 of section 32, read with section 12A of the National Council for Teachers Education Act 1993, and in supervision of the National Council for Teachers Education, determination of minimum qualifications for recruitment of teacher in school regulation 2001, except as respect things done or omitted to be done before such suppression, the council hereby makes the following regulations. These regulations have been framed by NCTE, my lord, under the NCTE Act. It prescribes minimum qualification for persons to be recruited as education teacher and physical education teacher in pre-primary, primary, upper primary, secondary, senior secondary, intermediate school. We are for secondary school, my lord. Next page, table is there, my lord, as first schedule. Next page. 4. Serial number 4. These are secondary, higher secondary school for teachers, my lord. Graduate, postgraduate from recognized university with at least 50% marks in either graduation or post-graduation and Bachelor of Education from National Council for Teachers Education recognized institution. And the other criteria is there, my lord. But this regulation does not prescribe for TET, my lord.
So there is no repugnancy.
My lord, since my lord, the central legislation is silent about requirement of TET in respect of graduate teachers. So my lord, the state respondents.
That doesn't mean that they can't this pose any further this qualification for that.
My lord,
That doesn't mean.
Moni go back. Moni.
My lord, in this case, we have challenged the virus of the rules, my lord. Yes. Now, if a lordship will kindly
Petition.
take the repetition, my lord. Now, please come to page 36, my lord. नहीं, अच्छा। तो क्या?
My lord, I have received the affidavit from the NCT, my lord. So I will file it today, my lord. In the course of the day.
NCT, where is the question?
NCT, my lord. No, I think they have a role, my lord,
Regulations will be learned.
because the regulation is of the NCT. My lord, our simple case is entry 25 of list 3 is subject to entry 66 of list 1. And if you want to override it, in that case, you'll have to, whatever you do by complying with Article 254. Now, you cannot prescribe something which is not there in the. No. Oh, they can make a- He get the question. I like question. Wait, how much is it? Represent alage.
When you are going to file?
In the course of the day today, my lord, sir. Maybe some-
Today itself?
My lord, lordship must have seen that NCT latest notification is not even required. TET. It is only required for primary and ME sections. And we are TET pass, my lord. Our certificate is valid up to
You have
27.
already passed that. Yes. Learning council appearing for the NCT has submitted that he'll file, he is going to file counter to the petition today itself. List on Thursday,
My lord.
20th of August.
My lord. I think next item will be also same, my lord. Hetu affidavit file.
They both are connected.
Yes. Next, along with. I'm sorry, my lord, I was on legs in court number 4.
Passover method 10.
Yeah, please. I may allow 1 week time to file an affidavit in state regards.
Do you have some good instructions? Or
They have told me that to put up on mail everything so that we will make on affidavit.
after a week?
Item 13.
Senior counsel is just coming. Senior counsel cancer is coming also. Kindly pass over timing. There was a matter of fixed.
Item 17.
May I please, your lordship. Lordship, I beg for little accommodation for today, my lord. For this matter, my lord. On the next week, my lord, if convenient, my lord.
The last date, on your request also, this accommodation was, given. The date was fixed in the presence of, you are N Gautam?
No, my lord, I am a surgery.
Last, it was,
Yes, my lord, from the petitioner side.
this was understanding that, and, argue the matter.
I had to go to Borda Lordship from Bombay this morning. I came only because of this matter. Just now I am directly
Yes,
coming.
Mr. Chaudhary is here.
Or if Lordship is adjourning it, then let it go for due course of time for hearing. I have no objection.
17.
No, well, I couldn't follow, my lord. Why this so urgency today? There are so many other cases. My learned friend also takes time. We don't object. Today, my lord,
He's not, objecting the adjournment, but he's saying that then it may be listed.
no, my lord, I'm not saying that. I'll do the case. Kindly give me 10 minutes time. Let me go through it. I'll do it. Yeah, I'll do it. The only thing is, my lord, this should be reciprocal.
No doubt.
Yeah, I'll do that. Yes,
Item 18.
Just in the month of September.
No, Lordship, there is urgency. Maybe after 2 weeks, Lordship.
2 weeks, almost, half of the August to go. September, September,
In the last week of August, Lordship.
then September only.
Because they are taking time.
Last
Other,
week of September, and one the same thing, Mr.
we have so urgency because there
Okay,
is
last week of August.
Lordship.
Ready with 30. ফাইল পড়ে আছে এখানে তো
Item 13.
May it please your lordship. My lord, these petitioners, the appellants, they are presently working as in the Assam, this Pollution Control Board, my lord. Now, regarding their upgradation and the promotion, a challenge was laid, and that is how we are before your lordships now. If your lordships would first come to page number 247, my lord. This is a minutes of the 75th board meeting held on 19th of June 2001 in the office chamber of the chairman, Pollution Control Board. The relevant resolution with which we are concerned, that is at page 251. Serial number 8. Book list can be that. Upgradation of the post of junior engineers to the assistant engineer as per the Central Pollution Control Board norm. The member secretary apprised that the board that as per Central Pollution Control Board, no diploma engineers should be requisitioned and existing diploma engineers should be upgraded from the post of junior engineer to assistant engineer, aiming at increasing the efficiency of the engineering services of the board in future. The Central Pollution Control Board also desired the state boards to follow the said policy. The matter was discussed, the board agreed to the policy in principle. But considering the present financial position of the board, it is resolved to upgrade those posts of junior engineers which have confirmed eligibility of the norms page-wise. Board will not fill the present vacant post of assistant engineer till it is decided by the board otherwise. Member secretary of the board will submit service sheet of the upgraded engineers, parawise specifically mentioning the period of qualifying service, the scale of pay, basic pay, departmental proceeding, if any, of the junior engineers for final approval of the board. So, my lord, based on the direction of the central board, a decision was taken by the state board for upgradation of the post of junior engineer, basically those diploma engineer to that of the assistant engineer. And the underlying idea was to increase the efficiency in the work. Now, my lord, pursuant to this decision at page 149, sorry, 147, my lord. (147). Under Rule 22 of water pollution, so and so as amended, the following 14 junior engineer of this board, having experience of more than 10 years of service, are upgraded to the post of assistant engineer with immediate effect. My lord, serial number 1 is appellant number 1. Serial number 5 is appellant number 2. Serial number 6 is appellant number 4. Serial number 7 is appellant number 7. Serial number 8 is appellant number 3. Serial number 9 is appellant number 5. Serial number 10 is appellant number 6. Serial number 11 is appellant number 8. Serial number 12 is appellant number 9. And serial number 13 is appellant number 10. So these 10 diploma engineer, junior engineers were upgraded in the year December 2005. Thereafter, my lord, at page 141, my lord, this is the minutes of the 102nd board meeting of Pollution Control Board. If your lordships would kindly come to page 142. From assistant engineer to assistant executive engineer towards the bottom, my lords, at page 142. 10 years of minimum total service as assistant engineer in the board. After thorough deliberation, 13 number of assistant executive engineer may be upgraded to executive engineer. 2 number of assistant executive engineer scientists may be upgraded to the post of executive environmental scientist. Now we are concerned. And 5 number of assistant engineer may be upgraded to assistant executive engineer, keeping the cadre strength at 264 number as revised on 2013-14. These upgraded posts will automatically come to original cadre upon retirement, termination, resignation of the above mentioned post. The board member has agreed to upgrade this post under section 4.3, chapter 2 of Pollution Control Board, so and so employee service regulation. However, intimation may be sent to the state government. So, my lord, some of the appellants, they were upgraded, my lord. Then, my lord, will kindly come to page number 92. This is a gradation list of the assistant engineer as on 1/2/2020, my lord. If your lordship kindly comes to page 92, serial number 1 to serial number 10 are the appellants. And serial number 12 was the writ petitioner, my lord, who is a direct recruit. Serial number 1 to 10 are the appellants, 1 to 10. And serial number 12 is the writ petitioner, who is a direct recruit. In fact, my lord, date of joining as assistant engineer is 1/8/12. Whereas we became assistant engineer in 2005. Yes. Then my lord will kindly come to page 109. This is a minutes, selection committee minutes of 15/9/2020. My lord will kindly come towards the bottom. The heading is promotion of assistant engineer to assistant executive engineer. At page 109. There are, may I read it, my lord? Page 109. There are 3 vacant posts in the cadre of assistant executive engineer, and 3 resultant vacant posts of assistant executive engineer will occur consequent upon promotion of assistant executive engineer to executive engineer. These 6 number of posts are to be filled up by promotion from lower cadre, that is assistant engineer, as per the Pollution Control Board Assam Service Regulation 2012. Next please. The position of roster are 1, 1st, 5th, 8th, 10th, 12th in the relevant register for the aforementioned post. 1st and 12th are unreserved. 5th is STP category, 8th is SC category, and 10th is STH category in the register. The relevant Pollution Control Board Assam Employees Service Regulation 2012 and the gradation list of the employees showing the seniority are placed before the selection committee. There is no vigilance case departmental proceeding pending against them as provided by the member secretary, copy and close, observation and recommendation. After considering the educational qualification, experience of ACRs, the committee recommends promotion of the following assistant engineer to rank of assistant executive engineer for the position 12th and 17th respectively. Thiren Sharma, that is appellant number 1, and Jayanto Kulodhipati is appellant number 2. That is against the assistant existing vacancy. For the resultant vacancy against roster point 1st, 5th, and 8th in the roster register, the appointing authority has placed ACR of eligible incumbents. The selection committee members have gone to the ACRs of the incumbents and recommend the following assistant engineer to rank of assistant executive engineer for position 1st, 5th, and 8th after issue of office notification joining of Sri M.K. Das, so and so, so and so, so and so, AE to the post of executive engineer respectively. So Benudhar Kolit Talukdar is appellant number 3, Mr. Pathak Chandra Boro is appellant number 4, and Aurobindo Das is appellant number 5. So my lord, 2005, the appellants were upgraded as assistant engineer, and subsequently appellant number 1 to 5 were promoted and appellant number 6 to 10 were, my lord, upgraded. Now the promotion orders are at page 114, pursuant to this. Page 114. This is on 8th of October 2020. My lord, I am not reading the content. Kindly notice the names, my lord. Dhiren Sharma, Jayanto Kulodhipati, Benudhar Talukdar, and Pathak Chandra Boro. Then at page 115 is Aurobindo Das. And at page 116, my lord, the order relating to appellant 6 to 10. In pursuance to the decision taken in 102 board meeting held on 9/1/12/2019 under agenda item number 3, and as per the approval of the Environment Forest Department, Government of Assam, by letter dated 13th of July 2020, the following assistant engineers are allowed to hold the upgraded post of the assistant executive engineer with effect from the date of their joining in the original place. The pay and other promotional benefits will accrue to them with effect from the date of their joining. So my lord, Bijoy Baria is appellant number 6. Gautam Nandi is appellant number 7. Jayanto Kumar Datta is appellant number 8. Ujjwal Kumar Sharma is appellant number 9. And Nogen Chandra Boro is appellant number 10. Now, my lord, this upgradation as well as, my lord, the promotion were put to challenge before the learned single judge, and learned single judge has interfered with the, my lord, both promotion and upgradation, and that is why we are before the lordships. While admitting this petition, interim orders were passed, and we are continuing in the, my lord, promoted post. So this is the factual background. Now, my lord, the issue is, if your lordship should kindly, copy. In the meantime, my lord, the writ petitioner respondent has also been promoted. Now, essentially, the issue boils down to seniority. তাহাঁতৰ বেছিক কেছ হ'ল আমাৰ কোৱালিফিকেশ্যনৰ, নহয় জানো? My lord, the basic case of the writ petitionary is the regulation 9(2)(b), sorry, 2 prescribes the qualification of either BE or BTech. So their contention is, since we do not have the qualification, therefore we could not have been either upgraded or promoted. That is their case. Assistant executive engineer করেছে, assistant engineer করা না এখানে। হুম। Thirteen to 17 তো আপনার ছিল না? মানে আমার কাজটা দেখতে হলো নাকি কিছু that is just 13 to 17 you have to have completed. 13 to 17 আমি কি জানি আমি 1 to 6 1 to 6 April and 1 to 6 over there. Now page 83 83 prayer number 5 13 to 17 6 to 10 अभी एक कितना 7 8 9 7 11 A
So Chaudhary, what is the core controversy? here?
yes, please come to page 59 para 8 of the writ petition. That is their case.
Para 8 of the writ petition.
Yes, part of the writ petition. Now it is in the paper book at page 59. This is their case.
Yes.
Towards the bottom last two sentence, that the petitioner respectfully begs to state that Regulation 9 of the Pollution Control Board Assam Employee Service Regulation 2012 stipulates the manner in which promotion has to be made to various cadre and qualifications so required for being appointed and or for promotion to the higher grade from the feeder cadre. Table 2 of the Appendix 2 clearly states that cadre of assistant executive engineer has to be filled up 100% by way of promotion, and the incumbents will require to have 5 years of qualifying service in the feeder cadre of the assistant engineer and must have a degree in BE, BTech, AMIE in so and so branch. Further, it stipulates that diploma holders will be eligible for promotion to the higher grade if they have been promoted and not upgraded in the cadre of assistant engineer, wherein they are presently working. Now, what is their case is, my lord? Basically, what we don't have is the BE degree.
Yeah.
That's the point. Now, our upgradation as assistant engineer was never challenged. We were upgraded as assistant engineer in terms of the decision of the central board in 2005. We got
While
the,
working as junior engineer.
yes, and it was on account of administrative exigency. And administrative exigency is always in public interest. This aspect the learned single judge did not consider. And in the case, a particular appendix of the rule regulation will have to be interpreted, my lord. I can straight away come to that. I think, my lord, 2 copies of the regulation is already there. Yes, the white one, my lord. The regulation of 2012. I'll rely upon 2-3 provision, my lord, then it will be very clear. Please come to page 3 first. Chapter 2, page 3. Regulation 4. The services of the board shall comprise the categories of posts as mentioned in table 1. Board may include any other category of posts or posts under the services of the board or exclude from the posts listed in table 1 as and when felt necessary for smooth functioning of the board and in public interest temporarily for a period not exceeding 2 years by board decision and on permanent basis with due approval from the government of Assam. Now, Lord will kindly come to small 3. The board may by resolution may upgrade or downgrade posts within the sanctioned strength. However, any addition to the existing strength of the cadre shall be with the approval of the government of Assam. So, my lord, there is power given to the, board in an appropriate, situation, my lord, to upgrade the post. Then my lord will kindly come to regulation 7.4 at page 6. Now, perhaps what my learned friend may like to argue is 7.1. Method of recruitment. Any appointment to the services under the board shall be made by the appointing authority by any one or more of the following method: by direct recruitment, by promotion, deputation, compassionate ground on contract. Perhaps my learned friend, in fact, they have pleaded also, my lord, that upgradation is not one of the mode of recruitment. That's what they have said. Now, please come to Roman 4, which is important. The number of vacancies under various cadre and their percentage for direct recruitment and for promotion from the next cadre shall be decided by the board authority. So I'm just outlining, my lord, the power which has been given to the board by the regulation. Then the lord will kindly come to regulation 9 at page 8. But I'll have your lordship's kind attention at page 9 to that Roman 2 qualification, experience and promotion of employees under the engineering and technical service. This is the regulation which they are harping, my lord.
Yes.
For recruitment to the cadre of assistant engineer in the board, the required qualification would be bachelor's degree in engineering, BE, BTech or BSc in engineering, in chemical, civil or environmental from any recognized Indian or foreign university or AMI of Institution of Engineers India. The educational qualification and experience for the other posts under this service shall be as per table 2 in appendix 2. Now, my lord, this is important. Page 33 is the appendix. Page 33. The heading is statement showing cadre-wise service criteria for initial recruitment and promotion. Then please come to capital A, engineering and technical service. From my lord, ascending order sorry, descending order, chief environmental, additional chief, senior executive. Serial number 5 with which we are concerned, my lord. Assistant executive engineer. At page 33. Now, if your lordships kindly comes to column number 8, minimum year of experience, 5 years service as assistant engineer in board, which we have, my lord, there is no dispute. Now, please come to the last column. This is where, my lord, my humble submission would be, some interpretation has to be given because of the intervening developments in this case. For existing promotee engineers, the qualification shall be relaxed to diploma in engineering. Am I clear, Miller? The remark, column number 9. For existing promotee engineers, the qualification shall be relaxed to diploma in engineering. So same is the requirement in case of promotion from assistant engineer to assistant executive engineer, provided one is a diploma holder.
Single judges held, they are not promoting engineers.
Yes.
So remarks column will not be.
Yes. Now, my lord, our case would be, now when there is a provision for relaxation in the rule, and when the authority does something consciously, then Supreme Court says it is in dim relaxation of the rule. Number 1. Number 2,
Relaxation power is there.
yes, I'm coming to that.
Where is that?
Yes. Rule number 49, regulation 49. Page 31. On top, my lord,
Where the,
at page 31.
yes,
Where board is satisfied that the operation of any of the conditions under this regulation cause undue hardship in a particular case, the board may order to dispense with or relax the requirement of that regulation to such an extent and subject to such condition as the board may consider it fit and proper for dealing with the case in just and equitable manner by a board resolution, provided that the case of any person shall not be dealt with under this regulation in any manner less favorable to him than that provided by any of these regulations. Now, my lord,
There is no
question-
regulation, there is no board resolution to that.
there is no board resolution, but my lord, in my humble understanding, the law is whenever an authority consciously does something in derogation of the rule, then it has to be construed to be done in relaxation of that power. Because non-mentioning will not make the position fatal. And one more thing, my lord, we were upgraded as assistant engineer in the year 2005. Those orders have attained finality. Nobody has put to challenge. This assistant executive engineer promotion we got in 2015. Therefore, to say that we do not have qualification, therefore we could not have become assistant engineer, we could not have become assistant executive engineer. My lord, this is too far-fetched, my lord. There is a delay. By virtue of the delay on the part of them, we have acquired a valuable right. Now, my lord, the law on this point, I would like to place 2-3 judgments where the Honorable Supreme Court has clearly said, my lord, my lord will kindly take note of 2-3 things. Upgradation order dated 31/12/2005, as well as gradation list was never challenged. Now, my lord, their case is, as I have already indicated, para 8 and 9. And thirdly, there is delay of 16 years, which is not at all explained. These writ petitions were filed in 2021. And my lord, we were upgraded in 2005. And that was in administrative exigency. My lord, on this dim relaxation, can I place 2-3 judgments, my lord? First, I would like to place, my lord, 1986 2 SCC 157. JC adopted relaxation of it, right? My lord will kindly take paragraph 16 and 17 at page 171. Rule 16 is quoted at para 16. The government may, in consultation with commission and for reasons to be recorded in writing, relax any of the provisions of these rules with respect to any class or class category of person or post, and no such relaxation shall be given so as to have retrospective effect. GS Lamba case may be carefully considered at this stage. In that case, this court was concerned with Indian Foreign Service, which was governed by Indian Foreign Service Branch B Recruitment, Cadre Seniority and Promotion Rule 64. The said rules provided for recruitment to the said service from three different services: direct recruitment by competitive examination, substantive appointment of persons including the select list promoted on the basis of LDE, and promotion on the basis of seniority. One of the rules provided that the recruitment should be made from the above source on the following basis: 1/6 of the substantive vacancy to be filled in by direct recruitment, 33 1/3 of the remaining 5/6 of the vacancies to be filled up on the basis of results of limited departmental examination, and remaining vacancies to be filled in by promotion on the basis of seniority. The court found that direct recruitment had not been made for years. Limited examination had also been held for years, had not been held for years, and promotion from the select list had been made in excess of the quota. It found that there was enormous departure from the rules of recruitment in making appointment over several years. The court was of the view that the situation in this case was similar to the situation in two other earlier cases of this court in Janardhan and O.P. Singla. The court felt in the circumstances it should be presumed that excess appointment by promotion had been made in relaxation of the rules, since there was power to relax the rule similar to the power under Rule 16 in the rules with which we are concerned. Justifying the above view, the court observed that so and so. It was, however, contended that it is not possible to infer that promotion in excess of quota were given by relaxing the quota rule, because the posts in the integrated grade 2 and 3 were within the purview of the UPSC, and proviso to Rule 29A mandates that power to relax is hedged in with a condition that it cannot be done after consultation with the commission, and there is nothing to show that commission was ever consulted. Undoubtedly, the proviso to Rule 29A requires that controlling authority cannot relax any of the provision of the rule in respect of the post which are within the purview of the Union Public Service Commission, unless after consultation with the commission. It was submitted that nothing is placed on record by petitioners to show that power to relax the quota rule was exercised after consultation with the Union Public Service Commission. Assuming that there was no consultation, would the exercise of power to relax be vitiated and appointment made in relaxation of the mandatory quota rule would be void initio invalid. Commencing from the decision of the Privy Council in so and so, it is well settled that when the provisions of a statute relate to the performance of a public duty, and the case is such that to hold null and void acts done in neglect of this duty would work serious general inconvenience or injustice to persons who have no control over those entrusted with the duty, and at the same time would not promote the main object of the legislature. It had been the practice to hold such provisions to be directory only, the neglect of them, though punishable, not affecting the validity of the acts done. The view was expressed in the context of failure to revise the list of jurors by the sheriff according to the revised statute of Quebec, and conviction was challenged on the ground of ministerial held by selecting jurors from the unrevised list. The challenge failed. Then Lordship may kindly skip that next sentence, then the sentence starting with, there are number of subsequent decisions to which our attention was called, reiterating the same principle. Therefore, assuming there was failure to consult Union Public Service Commission before exercising power to relax the mandatory quota, and further assuming that the posts in the integrated cadre 2 and 3 were within the purview of the EPSC, and accepting for the time being that the commission was not consulted before the power to relax the rule was exercised, yet the action taken would not be vitiated, nor it would furnish any help to the Union of India, which itself cannot take any advantage for its failure to consult the commission. Therefore, it can be safely stated that enormous departure from the quota rule year to year permits an inference that departure was in exercise of power of relaxing the quota rule conferred on the controlling authority. Once there is a power to relax the mandatory quota rule, the appointment made in excess of the quota from any given source would not be illegal or invalid, but would be valid and legal as held by this court in N.K. Chauhan. Therefore, promotion of the promotee was regular and legal, both on account of fact it was made to meet the exigencies of service in relaxation of the mandatory quota rule and to substantive vacancies in service. The court ultimately quashed the seniority list and directed preparation of seniority list on the basis of the length of continuous officiation in the cadre. The facts in this case being almost identical, there is no reason why the view expressed in G.S. Lamba should not be adopted here also. The continuance of these petitioners may be justified on the basis of the above quoted Rule 16 on assumption that government had relaxed the rules and appointed them to the post in question to meet the administrative requirement. So, my lord, this is the view. Then, my lord, the other judgment on this deemed relaxation, which I would like to refer is, my lord, to a 1992 SCC 189. SCC 189. Lord, I will refer to para 5, 6, and 10. 5, 6, and 10. My lord, at para 5, Rule 22 of the rule, which is more or less on the similar line, is quoted. Now, may I have your lordship's kind attention to para 6? The rule confers power on the government to dispense with or to relax the requirement of any rule to the extent and with such condition as it may consider necessary for dealing with the case in a just and equitable manner. The object and purpose of conferring this power on the government is to mitigate undue hardship in any particular case and to deal with a case in a just and equitable manner. If the rules cause undue hardship or rules operate in an equitable manner, in that event, state government has power to dispense with or relax the requirement of the rule. The rule does not restrict the exercise of power to individual cases. Government may in certain circumstances relax requirement of the rules to meet a particular situation. The expression in any particular case does not mean that relaxation should be confined only to an individual case. One of the meanings of the expression particular means peculiar or pertaining to a specified person, thing, time, or place, not common or general. The remaining of the word particular in relation to law means separate or special, limited or specific. The word case in an ordinary usage means an event, happening, situation, circumstances. The expression case in the legal sense means a case, suit or a proceeding in the court or a tribunal. Having regard to these meanings, the expression in any particular case would mean in a particular or pertaining to an event, situation or circumstance. Rule 22 postulates relaxation of rules to meet particular event or situation. If the operation of the rule causes hardship, the relaxation of the rule may be to the extent the state government may consider necessary to deal with a particular situation in a just and equitable manner. The scope of the rule is wide enough to confer power on the state government to relax the requirement of the rules in respect of an individual or class of individuals to the extent it may consider necessary for dealing with the cases in a just and equitable manner. The power of relaxation is generally contained in the rules with a view to mitigate hardship or to meet a particular situation. Many a time, strict application of service rule create a situation where particular individual or a set of individuals may suffer undue hardship. And further, there may be a situation where requisite qualified persons may not be available for appointment to the service. In such a situation, government has power to relax the requirement of rules. State government may, in the exercise of its power, issue a general order relaxing any particular rule with a view to avail the service on the requisite officers. Relaxation, even if granted in general manner, would ensure benefit to individual officers. Then my lord will kindly come to paragraph 10.
Mr. Chaudhary, there is only one writ petitioner.
Yes.
He was appointed as assistant executive engineer after your clients were upgraded.
Yes.
But he is claiming seniority above all of them on the ground that he has the qualification, but
And
they
we don't have.
So, in a way,
But he was born in the cadre in 2012.
that
And
is
we were
after
born in the cadre in 2005.
2005.
What is the stand of the state government?
My lord, the board is supporting us. No, it's a case of the board, my lord.
Board is supporting.
Yes.
What they are saying that the relaxation was granted.
Yes.
Affidavit has been
There's a
filed.
government approval also.
And is he invoking the principles in Rafiquddin's case? No,
No.
that is not.
No. No, Rafiquddin principles would perhaps not come in my humble submission, my lord. It was in administrative exigency. My lord, we never prayed that we should be upgraded. Now, why should we face the music, my lord? It makes no sense. It will be too onerous. If today we are to be
And you say that the order of upgradation was never challenged.
never challenged.
What is the challenge now?
The challenge is there are two orders, my lord. One order by which appellant number 1 to 5 was promoted, and one order by which 6 to 10 were upgraded.
So all these have been set aside.
Yeah, all this has been set aside.
Upgradation, how he was agreed by the upgradation of the respondent number 6 to another?
No, they say the upgradation cannot take place because we don't have the qualification of B.
How he is agreed by that?
I don't know, my lord. He's agreed. That is only case. His entire case is based on regulation 9(2).
Maybe, but at least what is his grievance? Suppose in case where the promotion.
No, his only grievance is, my lord, perhaps his grievance is twofold. Relying upon regulation 7(1), he would ideally like to contend that upgradation is not a mode of recruitment, number one. And secondly, we do not have the qualification to even hold the post of assistant engineer. So there is where is the question of either upgradation or promotion. That is his case.
Who is for the private?
Perhaps my learned friend appears.
Have you read these judgments?
Yes, sir. I would like to say that this judgment, my respected senior is relied on. That is clear number. And the other judgment, that was in respect of quota, wherein the promotees were promoted in excess of the quota. Whereas there are judgments of the Supreme Court, which says that there is nothing called deemed relaxations, there is nothing called implied relaxations. The service rules are the core issues, and these rules of recruitment cannot be relaxed. Now, regulation 7 categorically says that. One thing fell from your from this honorable court that how I'm agreed by the upgradation. Your lordship, the upgradation was put to challenge because first of all, the regulation does not speak of upgradation, and it has become a regular business of the pollution control. Yes, of course, the post can be upgraded. After upgrading the post, you can promote those people. If the questions, the manner in which the upgradation is not been laid down by the regulation, how the board could have upgraded all those?
Upgradation provision is there in the regulation.
Yeah. Your lordship, it says upgrade the post.
Yeah,
And the manner in which the upgradation has to be done, the Supreme Court has laid down the law.
In the upgradation, upgraded the post.
Yes,
And the persons who are working on those posts
yes.
deemed to be upgraded to that post.
In my humble submission, that's not the right word. I mean, this on the law. These posts were upgraded. If a lordship kindly looks at regulation 4(2), page 3 of that regulation. Yes, the lordship. My respected senior has read 4(1) and 4(3), but he has not read 4(2). And 4(2) has to be read in conjointly with 7.
Yes.
Members of the cadre shall have no claim for appointment to any other cadre except in accordance with the provision made in this regulation. First. Secondly, 4(3), the board by a resolution may upgrade or downgrade posts within the sanctioned strength. However, any addition to the existing strength of the cadre shall be with the approval of the government. Now they can upgrade the comments. Now your lordship has seen the method of recruitment, that is by promotion, direct recruitment, deputation. There is no update. So rule 4(3) has to be read with rule 7, regulation 7. Secondly, the manner in which the promotion has to be done, it is clearly envisaged in the regulation. But this regulation does not speak the manner in which upgradation has to be done. Who are to be considered for upgradation? Whether that upgradation is permissible or not. And when the regulation does not speak of any upgradation, how can the board resort to such an illegal?
Clarification to the
And if your lordship.
Now do one thing.
And your lordship will kindly look.
Do one thing. You please, there are some, we just want to, grab whatever what is the controversy is. And
Yes, madam.
you please give us the judgments.
Yes.
You have already relied upon, you also give us the
Yes,
judgment.
yes,
We'll go through that
yes.
and then we'll hear you.
Millard, only one more thing, Millard. I'm just giving one judgment.
Yeah.
In similar circumstances, in Delhi higher judiciary, Millard, the upgraded persons were similar argument as my learned friend is making was made, which was rejected by the Supreme Court. S.N. Dhingra versus Union of India. We'll give Millard.
Mr. Chaudhary, why don't both of you give a short?
Yes, yes.
note
Yes, we can give.
with
Along
the
with the
citations?
Yes, yes.
It'll be easier if we consult the law and then.
Will it be too late if we give it on Monday, Millard?
We'll fix it on, next Thursday.
Yes, your lordship.
As the book is nothing. Yes, Thursday, Millard.
Your lordship,
On Monday, we'll give the Millard note.
lordship permit me, can I point out one thing? Your lordship, kindly permit. Page 116, the upgradation. After upgrading, the lordship will kindly read between the lines what they want to do. In pursuance to the decision taken in the 102nd board meeting held on 9/12/2019.
Page number.
Page number 116, I'm sorry, your lordship.
Yeah.
Under agenda, oh, sorry. Has the lordship got it?
Yes, 116.
In pursuance to the decision taken in 106 board meeting dated such and such, under agenda number 3, as per the approval of the Environment and Forest Department, Government of Assam by letter dated, the following assistant engineers are allowed to hold the upgraded post of assistant executive engineer with the effect from the date of the joining. The pay and other promotional benefit will accrue with effect from the date of joining. In the guise of upgradation, they have been promoted. Your lordship, I would say, in my humble submission, the Honorable Supreme Court has said, this is not upgradation. What is upgradation and promotion? That has been defined by the Supreme Court.
That Bharat judgment.
In Velaswamy's case, your lordship.
Then
2020.
Learned single judges placed reliance for.
Yes, your lordship. So in my humble submission, this should not have been disobeyed. And what is the exigency of the survey? When 15 graduate engineers were there, how can they say there was an exigency of service? And as regards 2005, I'm not challenging. I have no business to challenge that. I was not born in the cadre. But the regulation came in 2012. If they were affected by the regulation, they would have challenged this regulation. They have not done it. That's what a constitutional bench of the Supreme Court has said.
Okay, let's give us a note.
By
Monday.
Monday, we'll give it
Yeah,
you.
Monday. Thursday,
Along with the relevant judgments,
Thursday.
the lordship will keep it as part.
Yeah.
Your lordship will keep it as part, right?
Yes, yes.
Part. Arguments heard in part. This not Thursday की date. This one
Sunday to Monday. আমাকে মাতিব চাগে না? লাগিব।
Item 17.
It will be. My lord, basically what, I'm not fully prepared, but whatever from I remember, I'll make this submission. Article 320 of the Constitution, my lord, it lays down cases where consultation with the commission is necessary. Now, if your lordships would kindly have Article 320. Sub-Article 3. What we are trying to say is, my lord, this provision has been violated. I'll have to read 1, 2 also. It shall be the duty of the Union and State Public Service Commission to conduct examinations for appointment to the services of the Union and services of the state respectively. It shall also be duty of the Union Public Service Commission, if requested by any 2 or more states, to assist 2 states in framing and operating schemes of joint recruitment for any service for which candidate possessing special qualifications are required. 3. Union Public Service Commission or the State Public Service Commission, as the case may be, shall be consulted on all matters relating to methods of recruitment to civil services and civil posts. So, my lord, the mandate of sub-article 3 of Article 320 is on all matters of recruitment to civil posts and civil services, Union Public Service Commission shall be, my lord, consulted. Now, the post with which we are concerned, prior to the impugned actions taken by the authority, my lord, the post selections were made by the Assam Public Service Commission. Now, these posts have been taken out from the purview of the Assam Public Service Commission and has been entrusted to an authority which is not a constitutional body. That is our basic grievance. Now, if your lordships will kindly come to the proviso in the next page, proviso 2, that's sub-article 3. Provided that President, as respects the All India services, as also as respects other services and posts, in connection with the affairs of the union, and the governor as respects other services than post in connection with the affairs of the state may make regulation specifying the matter in which either generally or in any particular class of case or any particular circumstances, it shall not be necessary for the Public Service Commission to be consulted. My lord, my humble understanding, subject to what your lordships may say, in terms of proviso to sub-article 3 of Article 320, the state government may frame a regulation whereby the consultation with the Public Service Commission can be dispensed. Now, that has not been done in this case. What the state has undertaken is an exercise under proviso to Article 309. That is the case. A very simple case. Let state show that an exercise under the proviso was undertaken. Limitation function কোন কোড আছে এখানে আছে এখন কিতাব আছে না
Mr. Chaudhary,
Yes.
is it your argument?
Yes.
That an exception made in a rule made under proviso to Article 309 would not come within the meaning of proviso to Article 323?
No, my lord.
Why is that?
No,
Why?
it's not. But that's what the Constitution says, because Article 309 starts with the word subject. Please come to Article 309. Please come to 309.
Yes.
It starts with the word subject to the provisions of the Constitution. So, before you invoke proviso to Article 309, you must have due regard to Article 323 proviso. Plus C, my lord, subject to the provisions of this Constitution, act of the appropriate legislature may regulate the recruitment and condition of service of person appointed to public service and post in connection with the affairs of the union or any state. My lord, when constitutional provisions are to be given a meaning, one need not find out prejudice. Either it is followed or face the music.
So you are saying subject to the provisions of Constitution means 309 proviso rulemaking power cannot extend to
No, it cannot. No, my lord. When you undertake an exercise, for example, I'll give an example, my lord. Entry 25, list 3, both union and state can make law. As far as educational links, etc. Now, it all entry 25 of list 3 also starts with the word subject to. Entry 66 of list 1. Meaning thereby, if you do anything, you must have due regard to entry 66. Similarly, if you want to invoke proviso to Article 309, you must have due regard to Article 320. If you have due regard to Article 320, that power is amenable only under proviso to Article 320. That power is not available under proviso to Article 309. Can, my lord, a constitutional mandate? Because state has done it. It's not that state do not law the law. Please come to this limitation function regulation 51. Please come to this book, page 91. State has done it. This 3F, 4D business, my lord, we all flow from this rule, regulation. Kindly see. State has already done it. Regulations specifying the matter in which it shall not be necessary to consult the Public Service Commission. In exercise of the power conferred by proviso to clause 3 of Article 320 of the Constitution of India, and in supersession of all previous orders on this subject, Governor of Assam is pleased to make the following regulation as respects services and posts in connection with the affairs of the state of Assam, specifying the matter in which it shall not be necessary for Assam Public Service Commission to be consulted. So they are oblivious of the legal position. So while framing this regulation, they did it in under proviso to Article 320, because here in making these appointments, consultation with APSC is dispensed with. So, my lord, these are all abstract proposition of law, my lord. Here there is no way we can, leeway.
So except for using the expression 309 and 320, what else is different here?
No, my lord, that we can't treat it that way. Maybe the state can now do it again by doing that. But fact of the matter is, when a challenge is laid, you'll have to,
Yes.
please come to page 77, my lord, the impugn regulation.
Yes.
In exercise of the power conferred by proviso to Article 309 of the Constitution of India, Governor of Assam is hereby pleased to make the following regulation in respect of the composition and staff of the Assam Engineering Service Recruitment Board, their tenure of the office and condition of service, along with the categories of the posts for which Assam Engineering Service Recruitment Board shall be conduct the recruitment process, and make recommendation to the state government for appointment in those posts. My lord, I'm making an argument for lordship's kind consideration, my lord. This constitution was drafted, my lord. We all know how it evolved. It was by the Constituent Assembly. My lord, it is said, in fact, in Keshavananda Bharati, Honorable Supreme Court had said that Parliament, in exercise of its ordinary legislative power, cannot amend the Constitution. Now, by a subordinate legislation, by proviso, under proviso to Article 309, a constitutional mandate will be bypassed. Is it conceivable, my lord? Even Parliament, in exercise of its ordinary legislative power, cannot tinker with a constituent provision. And now, as three bureaucrats sitting, my lord, somewhere, they will do it. My lord, Constitution felt that certain posts, if a recruitment is to be made, it is to be made by Public Service Commission. My lord, the fact that Public Service Commission are not made by good people, this is not the fault of the common people. It is the fault of the people who are in power. Therefore, can that the constitutional mandate be tinkered with like this? This could be on account of
This was the reason for framing these.
No, my lord, this is other way around. Let us not presume that, my lord. Where are the materials to show that?
This was the reason that since the people sitting in the APSC are not competent or not, that's why.
No, my lord,
they have framed
no, my
these
lord,
rules.
people, earlier, my lord, as far as Assam is concerned, I can make, I have seen, my lord, because there was a chairman called Arif Ali. He was the last of the good man who held the post. Thereafter, all this, because of this political interference, my lord, this has gone to dogs. Now we are seeing daily in and out.
It is
Not peculiar to this state, everywhere is happening. Now the question is, who are responsible? Why the common people should suffer? My lord, we feel more safe to face a selection by Public Service Commission rather than by these people, my lord.
So who is the petitioner here?
Petitioner, they are the aspirants.
One petitioner.
Yes. Two petitioners.
One is already,
One petitioner is surviving, my lord. I am an aspirant.
You are in employment and contract.
No, no, I'm seeking employment, my lord. Earlier I was in contractual appointment. 3F appointment was there.
Petitioner Roop Jyoti Beora.
Yes,
Only one petitioner.
yes. Rupjyoti psychology.
Any other major ground?
My lord?
This is the only ground?
Yes, basically this is the ground. Yes, this is the ground. The question is, my lord, how can you overcome this?
Yes.
My lord, my lord, in the writ petition, I have laid the foundation for my case. Kindly permit me to read 3 paragraphs, my lord.
Fine.
At page 19.
Yes.
Para 20. That the petitioners respectfully beg to state that Constitution of Assam Engineering Service Recruitment Board itself is a nullity, inasmuch as board cannot be entrusted with the function of Public Service Commission within the meaning of Article 320 of the Constitution of India. It is needless to point out that in exercise of power under proviso to Article 309 of the Constitution of India, Government of Assam could not have framed the Assam Engineering Service Recruitment Board Regulation 2021. That the fundamental issue which arises for consideration in this writ petition is whether state government governor in exercise of power conferred by proviso to Article 309 can override the constitutional mandate contained in Article 320 of the Constitution of India. The further issue which falls for consideration is whether power conferred upon the governor by proviso to Article 323 can be exercised by the governor in exercise of power under proviso to Article 309 of the Constitution. In the humble understanding of the petitioner, the answer has to be emphatic no, in view of the fact that exercise of power by the governor under proviso to Article 309 is subject to Article 320 of the Constitution of India. That having regard to the aforesaid legal principles, the notification dated 31/5/22, whereby Assam Technical Education Service Rule have been purportedly amended by Assam Technical Education Service Amended Rule, is non-est, and hence this honorable court cannot give judicial imprimatur to the impugned amendment. The impugned amendment in essence seeks to do away with the consultation with commission as envisaged in the rule of 81. Therefore, impugned amendment cannot be countenanced. Earlier, my lord, there was a requirement in the rule of consulting the Public Service Commission. During the pendency of this case, it was also amended. Therefore, the impugned amendment cannot be countenanced. In this connection, it will be relevant to state that state government governor is fully alive to the constitutional requirement in as much as Assam Public Service Commission limitation of function regulation 51 is framed in exercise of power conferred by proviso to Article 323 of the Constitution of India. That the petitioners state that the power conferred by proviso to Article 320 is not a power to be exercised randomly. In the comprehension of the petitioner, the power conferred by Article 323 is to withdraw certain posts from the purview of the Public Service Commission in certain administrative exigency is not a power to be exercised in a manner as has been exercised by the state while framing the impugned Regulation 2021, constituting the Assam Engineering Service Recruitment Board. What needs to be appreciated is that constitution makers felt it desirable that in matters of recruitment to the services and posts under the union and the state, the Union Public Service Commission or the State Public Service, as the case may be, shall be consulted. Instead of carrying out the said constitutional mandate, the impugned regulation as well as the impugned amendment would not have been enacted in exercise of the power under proviso.
The main argument.
Yes. Now, my lord, my humble submission is also, now, my lord, this power of, even the power to invoke power under proviso to Article 320, it is not a wholesome power, as Assam government is now regularly doing, my lord. In an exigencies of administration, where more time is likely to take by Public Service Commission to make some recruitment, then, my lord, this power can be invoked. This is not a permanent power, my lord. It's a power to be exercised in certain exigencies. It can't be exercised in a manner as has been done. Otherwise, my lord, what meaning we give to Article 320 itself or that part of the Constitution where a Public Service Commission for the state is envisaged? Otherwise, it's not required. My lord, the fact that Public Service Commission has been conferred with a function, there is a purpose. Now, my lord, let us not also assume that merely because this board is constituted, therefore everything will be fair. There's nothing like it. Nothing like it. So, my lord, now there is a fight between a constitutional body and a body created by an executive order. These are all executive orders. So, which will prevail? My lord, I'll rely upon 2-3 judgments. My lord, first judgment I will rely upon is 1979 4 SCC 507.
(79)(4) SCC.
Yes, 79 4 SCC 507. My lord, paragraph 25. The proposition is, my lord, in this case, by invoking executive power of the government, even a exercise of power under 309 cannot be overridden. Now we are pitted against a constitutional provision. Supposing, my lord, the field is covered by Article 309, there is a rule. Now, why this rule amendment is bad? I am coming to that basically. Can you see, my lord? Apart para 25 at page 514. Apart from repelling the contention that regularization connotes permanence, these observations furnish the second reason for rejection of the argument advanced on behalf of the promotees. And that reason is that when rules framed under Article 309 of the Constitution are in force, no regularization is permissible in exercise of the executive power of the government under Article 162. Therefore, in contravention of the rules, regularization order was made long after the probation rules, the seniority rules, and the recruitment rules were promulgated, and could not therefore direct something which should do violence to any of the provisions thereof. Regularization in the present case, if it meant permanence operative from November 156, would have the effect of giving seniority to the promotee over the direct recruits, who in absence of regulation would rank senior to the former because of the seniority read with the provisionary rules, and may in consequence also confer on the promotee a right of priority in the matter sharing the quota under the recruitment rules. In other words, regularization order in coloring the appointment of the promotee as assistant engineer with permanence should run counter to the rules framed under Article 309 of the Constitution of India. What could not be done under the three set of rules as they stood would thus be achieved by an executive fiat. Now, this is important. And such a course is not permissible because an act done in exercise of executive power of the government, as already stated, cannot override rules framed under 309. My lord, if there is a 309 rule or order holding the field, that cannot be overridden by an executive order. Now here in this case, my lord, what we find is, what subject to what your lordships may say, that they are trying to undo the constitutional mandate by exercise of power under proviso to Article 309. It is simply not permissible. But on the same line, I will not read it, same set of rules, judgment, my lord. 1998, 8 SCC 469, para 3, for the same proposition. 1998, 8 SCC 469, para 3. बाकी किनकी था किया सिगले पागले में Next, my lord may kindly come to 1995, supply 1 SCC 572. This is the judgment on point, my lord, regarding the propriety of invoking this power under, that is under proviso to Article 320. I'll draw your lordship's kind attention to paragraph 19, 20, and 21.
Yes.
At page 581.
Yes.
It is true that in Dibakar case and Venkat Reddy case, this court upheld the exercise of the power by the government under proviso to clause 3 of Article 320 of the Constitution, and in Venkat Reddy case, held that temporary employer appointed in accordance with the rules. As stated earlier, those appointments came to be made during ban period and remain in service for long. In this case, there is no ban on recruitment. The appellants were eligible to apply for the post and seek direct recruitment. In Paripurnam case, another bench of 3 judges considering similar Madras rule held in paragraph 14 that temporary appointments made under Madras, made under Rule 10A1 to fill up emergency vacancies were otherwise done in accordance with the rules, and the temporary service cannot be counted towards seniority. Same is the view held by the another 3 judges bench in APM Mayakutti versus Secretary. In Dibakar and Venkat Reddy, this court approved the validity of exercise of power under proviso to clause 3 of Article 320, owing to the ban on recruitment by the government and long lapse of time which had elapsed from the date of initial temporary appointment till the date the decision was taken by the government to regularize the services of such temporary appointments. In AK Bhatnagar, this court, while deprecating the practice of the government, giving a go-by to the statutory rules or regulations framed under proviso to Article 309, making large-scale departure expressed as thus. On more than one occasion, this court has indicated to the union and the state government that once they frame the rules, their action in respect of the matters covered by the rules should be regulated by rules. The rules framed in exercise of the power conferred under proviso to Article 309 of the Constitution are solemn rules having binding effect. Acting in a manner contrary to the rule does not create problem and dislocation. Very often government themselves get trapped on account of their own mistake or action in excess of what is provided in the rules. We take serious view of these lapses and hope and trust that government both at the center and in the state would take note of this position and refrain from acting in a manner not contemplated by their own rules. It was reiterated in Keshav Chandra Joshi, and it is common experience that it is vicious circle that initially government impose a ban on recruitment and make massive ad hoc appointment, dehouse the rule, giving a go by to make recruitment in accordance with rules, and then resort to regularization of such appointment, exercising power under Article 323 proviso or Article 162 to make them members of this service. This practice not only violates the mandate of Article 14 and 16, but also denies to all eligible candidates their legitimate right to apply for and stand for selection and get selected. In state of Odisha versus Sukanti Mahapatra and Narendra Mohan, it was held that appointments made in violation of the recruitment rules violate Article 14.6. Now, this is important. Therefore, as stated earlier, the administrative tribunal has rightly expressed unhappiness on the exercise of the power by the state government by resorting to proviso to clause 3 of the Article 320 to make massive departure to make recruitment in accordance with the rules. We agree with Guru Raja Rao, the Learned Counsel for the PSC candidate, that PSC must be made more functional and its efficacy be streamlined, appointing people of eminence, experience, and competence with undoubted integrity to recruit the candidates in accordance with rules for appointment to the post, and backdoor entry by nepotism be put to an end. Free play of exercise of power under proviso to clause 3 of Article 320 would undermine the efficacy of the constitutional institution. Well, the constitutional mandate which has been upheld in this case, in my humble submission, is court had even deprecated the practice of resorting to proviso to Article 323, not to speak of 309 proviso. So in that view of the matter, my lord, in my humble submission, well, at the end of the day, this government, they are repository of the trust of the people. We expect them to behave, my lord, rationally. Now, could it be more rational to follow the constitution? So my humble submission is, my lord, let this constitutional mandate prevail. Let the recruitment go on as it was being done. The world is not going to change overnight, my lord. Therefore, this regulation which seeks to take away the power of APSC is absolutely, in my humble submission, untenable in law and needs to be interfered with. As well as the amendment, my lord, made in the service rule, whereby, Lord, the power of selection has been given to that body, that should also be interfered with.
Yes.
That is my humble submission. With your lordship's kind permission, can I just reply?
So the first, one of the quick query, which the other side replied, that there is only one writ petitioner. That is the incorrect statement. Lordship will kindly come to page 5. Why they are hiding the second writ petitioner, there is a reason behind that also.
5.
Because both of them participated in the recruitment process. One is successful, one is not successful.
No, here the petitioner number 1 is only petitioner number 1.
No, there is 2. Kaushik Doctor is also there.
Huh?
If two petitioner,
I'm sorry to interrupt, my lord. Subsequently, he was strike out his name. There is an order of, my lord. I have filed for striking out the petitioner.
Please speak loudly.
My lord, the petitioner number 2, Kaushik Datta, his name was striked out, my lord. I have filed the IA, my lord. There is an order of this honorable court, my lord.
that copy is not served to us till date.
With the permission of the court.
Yes, my lord, there is an order of it, my lord.
So he participated.
And I
have
also filed the amended cost title, my lord. Therefore, my lord, one name is shown, my lord.
So this new body constituted under the new rules have already proceeded
We
with
have
the.
amendment. The original rule was of 1981.
Yeah,
We have amended it in 2022.
and thereafter recruitment process
Yes, recruitment process.
carried on.
Yes, and the rule was framed under 309. 320 C 3C is not a rule-making provision. That is a provision regarding whether the APSC or the UPSC should be consulted or not. That is why 309 very clearly starts.
But here you have, while exercising this power, you have this frame this,
We have amended 309.
Assam Public Service Commission Regulations 1950.
No, that is again incorrect submission.
This
I will
is
clarify everything. This is regarding to this temporary appointment under 3F, that is for 4 months, and for promotion of the temporary employees by 4D. That is regarding, that is not for direct recruitment. The direct recruitment rule is called, Lordship, the Assam Technical Education Service Rules 1981.
No, that's right. But what
They are trying to confuse, Lordship, because
no, they said the government is exercising powers under this clause 3 of Article 320 for framing the rules also, but herein ignoring that these
Absolutely.
provisions, now they have.
That is why I have to clarify this, Honorable Court, because they are confusing everything. Lordship will first take the rule of 1981.
Yeah,
1981, the Assam Technical Education Service Rules, 1981. In exercise of the power conferred by the proviso to Article 309. So this is the 309 proviso. In this rule, we have made 4 amendments. There are 4 amendments which is put to challenge. This is up to 2020. So the new rule, they have put to challenge where basically the 4 changes are from Assam Public Service Commission. We have replaced the word commission by board. That is the basic. If Lordship is pleased to look at the 1981 rules where we have made the changes. One change is at definition 2, sub definition B, 2B. The board has been inserted.
Where is that notification?
That notification I am facing it, Lordship. It's a
No,
part of
here,
the-
it is not on record.
It should be in the record. It is in the record that at page 86.
86.
86. Annexure 10. I think after the amendment petition, maybe the page number has changed, but.
86, yes.
86.
Annexure 10.
In exercise of the power conferred by the proviso to Article 309 of the Constitution, the governor is pleased to make the following rules further to amend the Assam Technical Education Service Rules 1981, which was also framed under 309, referred to as the principal rule. The rules shall be called so and so 2022. Amendment of rule 2 for clause B, the following shall be substituted. The board shall mean the Assam Engineering Service Recruitment Board, a statutory body constituted under Regulation 3 of the Assam Engineering Service Recruitment Board Regulations 2021. That we have also amended Rule 15. After clause 2, the following new clause shall be inserted, namely, committee means the selection committee constituted under Rule 15. Then in Rule 6, we have amended in sub-rule 1, in 4th line, the word commission, the board shall be substituted. And in sub-rule 1, the clause A, B, C, D, E, etc., the word commission wherever occurred, the word board shall be substituted. And in sub-rule 1 of clause C, in consultation with the commission shall be omitted. So what basically we have done, instead of APSC's consultation, this board will do the job. Whether that is permissible under the constitutional scheme or not, that is the core issue. The law is very well settled. I'll place all the judgments. And what prompted the state government to initiate this step in 2021 and 22? Because we requested from 2 numbers of engineering college, we increased it to 7. And from 10 number of polytechnics, we increased it to 26. So there is a huge requirement of entry-level professors, assistant professors, and other teaching faculties. We first made the request to APSC in 2017 for giving us the recruitment. Till date, that process has not completed. Lordship knows how the APSC was functioning from 2016 onwards. Not only the chairman, the whole committee was, the APSC selection committee was put behind bars. 62 officers, the direct recruitment in the APSC and APS, they were dismissed from service. Litigation is going on. In respect of agriculture departments, recruitment of the assistant agriculture officers, Last week, the final verdict in the trial came.
Those are the reasons. for
Those,
which
that is one part. One part is that. The other part is why the state government is not directly about this malfunctioning of the APSC. They were overburdened, number one. And they do not have experts in the field of engineering. Whenever we made a request to them to give us a recruitment process, to conduct a recruitment process for recruitment of various teaching faculties, they seek all the personnel from state government, experts. So we send all our experts body to them and they further continue.
That was the reason.
That is the reason.
Therefore, the state government has decided to
Decided that
go ahead with
we
the.
independently do it. To lessen the burden of APSC, number one, and to fashion the recruitment process in our department, in our institution. Till now, those new institutions are not having regular teachers. All this, including the writ petitioner, they were recruited for 4 months under the 1951 regulation, 3A. That is a purely ad hoc and temporary recruitment. That was done through APSC.
And they are continuing.
They are continuing there. That is why they are seeking adjournment from time to time.
Fine.
The last week, we got the learned single judge's order. The identical cases were before the learned single judge also. We are given the green signal to complete the recruitment process. That is why if this matter was adjourned also, there was no stay order in this challenge.
But since now you are.
Yes, now I'm finishing it, Lordship. Now, whether we can do it or not. Their whole contention is that we have amended the 1981 rule and brought this recruitment board, engineering services recruitment board. They were not very clear. So I am saying that we have amended the 2309 rules of 1981, brought the amendment, and subsequently also brought this board. Board also under 309. Page 77, Lordship will kindly come to Annexure 9, page 77.
Yes.
So in exercise of the power conferred by the proviso to Article 309. So under this proviso, we have constituted a board and various terms and conditions of their recruitment, pension, service conditions, etc. of the board members.
Fine.
So elaborate. So what they are trying to profess before this honorable court is that we have to do this under 30323, which is not actually the 3020 is only regarding consultation, and the rule making power is given under 309. And subject to that is the starting. So subject to all other provisions of the Constitution. So if we have to suppose 3020, we are inserting that 3023. Then we have to insert Article 14. We have to insert Article 20. That is not the scheme of things. So when we frame a rule under 309, we have to consider not only 320, but other provisions of the Constitution also. So there is absolutely no flaw in our whole lawmaking process. And there is no malafide. My learned friend is trying to input the government. The government wants a clear process. Now, the law is very well settled, and 320 article is not mandatory also. That is directory. That is also a well settled proposition. So I would like to place 4 judgments that will clarify the whole scenario. 1985, 1 SCC, page 120, paragraph 11. Jatinder Kumar versus State of Punjab.
1985, 1 SCC.
Sorry, I'm sorry, Lordship, 1989.
1980.
Yes, 1985, volume 1 SCC, page 122. Jatinder Kumar versus State of Punjab, paragraph 11. This is regarding whether Article 320 is mandatory or not mandatory. And the proviso itself provides that the governor in the case of state services and the president in case of union services can give up this consultation part. The proviso to Article 323 proviso. Paragraph 11.
Yeah.
Article 320 of the Constitution enumerates the duties of to be performed by the union or the state public service commission to conduct examination if requested by or requested to advise on matters enumerated under clause 3 of the Article 320. 4, to advise on any matters so referred to them and any other matters which the president or as the case may be the governor of the state may refer them. the fact that there is no provision in the constitution which makes the acceptance of the advice tendered by the commission when consulted obligatory renders the provisions of Article 323 only directly and not mandatory. This is one clear opinion of the Honorable Supreme Court. 1989, Volume 1 SCC, page 136, paragraph 12. Dr. M.C. Bindal versus R.C. Singh. Here also the same proposition, consultation with the State Public Service Commission is not mandatory, but
Nineteen
direct.
eighty-nine, one SCC,
136, paragraph 12. The paragraph 12 is quite long. So if Lordship is come to the last about 15 lines from below,
yes.
I'm coming, it is of course, have Lordship found it.
It is of course.
It is of course a well-settled legal position that the duty to consult the commission in the matter of appointment to civil post by the government is not mandatory but directory. And as such, the absence of consultation with the State Public Service Commission does not render any appointment made by the government in civil post invalid or illegal.
Fine.
The law is repeated here, but the original case is very important, Lordship. 1957 Supreme Court online court. It's a constitution bench judgment of 1957.
State of UP ML Srivastava.
Yes, Lordship. Paragraph 6 to paragraph 13. Elaborate discussion on Lordship, Article 320.
Paragraph 13.
Paragraph 7 onwards.
7.
Every line is important, Lordship. I will not take your, because this will be about 4 or 5 pages. So I'd like to please take your Lordship. I am referring to all these paragraphs, but the main paragraph which will help me is paragraph 12. We have already indicated that Article 323C of the Constitution does not confer any right on a public servant, so that the absence of consultation or any irregularity in consultation should not afford him a cause of action in a court of law, or to entitle him to relief under the special power of the High Court under Article 226 of the Constitution, or of this court under Article 32. It is not a right which could be recognized and enforced by a writ. Nothing remains thereafter, Lord. Very clearly says Article 32 as well as 26, for that this enforcement of right is not contemplated. And regarding withdrawal of posts, now these posts were earlier under the 81 rules, which said that it will be done through consultation with APSA. The government can always withdraw it. That power of the government to withdraw posts, it is very elaborately discussed in the case of Ashok Kumar Srivastava versus Ram Lal, 2008, volume 3, SCC, page 148.
UP case.
UP. Ashok Kumar Srivastava versus Ram Lal, 2008, volume 3, page 1, SCC, page 148, paragraph 77, 78. It is clear that the proviso, my learned friend has already read it, Lordship, while he made his argument, so I'm not taking your Lordship to that clause. It is clear that the proviso to Article, to clause 3 of Article 320 of the Constitution empowers the governor of a state to withdraw from the purview of the Public Service Commission services and posts in connection with the affairs of a state and to make regulations in support thereof. Precisely, we are doing that, Lord, by amending it. In the instant case, as has been indicated in details by the High Court, the state government took steps to withdraw 97 posts from the purview of the Public Service Commission after the commission expressed its inability to fill up the vacancies within a short span of time because of the various reasons indicated by it. As such,
has shortage of staff and the malfunctioning of obsolete machinery and equipment. It is in such circumstances and also on account of the fact that the collection of revenue was being seriously hampered, that the state government in its cabinet ultimately took the decision to withdraw 97 posts from the purview of the Public Service Commission and to have them filled up on the basis of an immediate departmental examination. So precisely our case also, we have various reasons in our affidavit. I'll just give the numbers where we have stated the reasons in our affidavit. So these cases clearly lays down what are the parameters we have to follow. The judicial pronouncement laid down the principle, and we have not violated any of the principles. So in Uma Devi's case also, one particular paragraph 6 plus 4 lines, 2006 volume 4 SCC, page 1. Paragraph 6,
2006,
volume 4 SCC, page number 1. This is also a constitutional bench judgment.
Uma Devi.
Uma Devi. Very widely.
Which
Paragraph 6 plus 4 lines. Therefore, when statutory rules are framed under Article 309 of the Constitution, which are exhaustive. Therefore, when statutory rules are framed under Article 309 of the Constitution, which are exhaustive, the only fair means to adopt is to make appointment based on the rules so framed. So how he is prejudiced, whether it is done by APSC or by this board? Absolutely no prejudice is being caused. Nobody is giving upper hand or lower hand. Everybody is getting a level playing field. Only thing is that we have to get the work done at a faster manner so that the colleges and institutions which are newly created do not suffer because of shortage of teachers and because there is a flaw in the pupil teachers ratio. The facts we have stated in we have filed 3 affidavits. The first affidavit, it was by Ubojyoti Bora.
There's no need of going to the facts.
Yes, the facts also.
We'll consider.
Lordship, highly obliged, Lordship.
What is it? Arguments or what is it?
Deeply obliged.
Obliged. Photocopies of the judgment
I'll give.
which you have referred?
Tomorrow morning, Lordship, along with the names and the paragraphs.
Fine.
Today itself we.